exactly what I read, I heard you say when I heard it read. That's all. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, everybody. Welcome to the August 3rd Jackson Township Planning Board meeting. This meeting has been appropriately noticed in all the appropriate places and forums according to the Open Public Meetings Act, and I will leave it off to Madam Chairwoman.
Good evening, everyone. We'll begin with a roll call, please.
Mr. Brezzi.
Here.
Mr. Marzo.
Here.
Mr. Heller. Mr. Parks.
Here.
Mr. Rogers.
Here.
Mr. Tremor. Mr. Sullivan.
Here.
Dr. Campbell.
Here. We need a motion for payment of voucher for recording secretary, please.
So moved, Sullivan.
Second, DeMarzo.
Roll call, please.
Mr. Brezzi.
Yes.
Mr. Marzo.
Yes.
Mr. Parks.
Yes.
Mr. Rogers.
Yes.
Mr. Sullivan.
Yes.
Dr. Campbell.
Yes. We need a motion for approval of the minutes for July 20th, please.
So moved, Sullivan.
Second.
Mr. Brezzi.
Yes.
Mr. Marzo.
Yes.
Mr. Parks.
Yes.
Mr. Rogers.
Yes.
Mr. Sullivan.
Yes.
Dr. Campbell.
Yes. Any engineering or planning matters, gentlemen? Any legal matters?
None at this time unless you want to.
We have no resolutions and no changes to the schedule, happily. There is one board matter I'd like to bring up. We have had a motion for reconsideration of an application site plan for block 1102, lot 24.02, and 1101, lot 3401. This is an unusual activity. In the 10 years I've been on the board, I've never been involved with this kind of thing. However, my legal counsel tells me that this is something that I will make a decision about. However, we're a board, and I want to make sure that you all have the opportunity to read the information that Mr. Shea will send to you before I make a determination, just so you're all aware. Thank you.
We will circulate it to the board.
Good. Okay, so we have application 23108, Mr. Doyle. You're not Mr. Doyle. I've known Mr. Doyle for 50 years, and you're not he. Use your microphone, please. Thank you.
Hello. All right. Good evening. My name is Avi Tober, and I'm an associate at the firm of Carluccio, Leone, Diamond, Doyle, Gutman, and Petra. We are here on the application. Do we have it as a?
Oh, you just speak into the mic?
You have to speak really into that microphone because we're recording and we're also on Zoom, so it's important.
Okay.
Thank you.
All right.
Anthony,
I think Anthony's pulling it up right now.
he's working on it. We had some issues earlier.
It's the
It's-
site plan for Mark Properties LLC.
Bath Street. Out on the Manchester border. $23,108, lot 14. That's it.
Okay. All right. So we're here on an application tonight. That's a 5-acre lot on Bath Street. That's in the RD1 district. It's also in the Pinelands. We are seeking to subdivide that into 3, and all 3 lots are going to be fully conforming lots, notwithstanding any other information. A little backstory before we begin on this property is that this property was actually approved with a resolution back in 2010, May of 2010. Due to complications, the subdivision map never got filed, so we're back here today. But it's essentially the same application. Nothing has changed much in the area. And like I said before, all 3 lots are going to be fully conforming for the area, for the zone. So with that, I'd introduce my expert, Graham McFarland.
Please raise your right hand, because we have no idea who you are. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right, please state your name and spell your last for the record.
Sure, it's Graham McFarland, McFarlane, professional engineer and professional planner. Yes, as indicated, this is an application for a minor subdivision for a parcel located on Bath Street.
Just the board accepts your credentials, since
We've
we've
seen this space
heard them many
before.
times?
Thank you. Yes, located on Bath Street and within the jurisdiction of the New Jersey Pinelands. You can see Exhibit A1 is an aerial map showing the subject property, which is currently vacant and wooded. It contains a land area of 5 acres. Located in the RD1 zone, it's proposed to subdivide this property into 3 conforming lots, each of them having an area of about 1.65 acres. Lot frontage, lot width of 133 feet and change will be provided for each of the 3 lots. The lots are in full conformance with ordinance requirements, not seeking any variances or waivers at this time. This is an application just for the minor subdivision. Anthony, just go to A2 for me real quick. This is the minor subdivision plan that was submitted in support of the application, shows the 3 lots proposed identified as lots 14.01, 14.02, and 14.03. You can see the setback lines proposed for the 3 lots. Interestingly, Pinelands required a front setback of 200 feet from the center line of Bath Street, so that is what's depicted on this plan. Even though the standard setback within a zone is 60 feet. I couldn't confirm what the impetus of that was, but that was also a condition of this original approval when it was done a few years back. So I think Pinelands just stayed with that requirement of having the homes.
I'll bet money that it's because that's what the setback is on almost all those properties. And it's probably in consideration for widening of roads. My guess.
Possibly, but Bath Street is a lower order residential street, only a 50-foot right of way. It's actually undersized right now. We do have to provide a 5-foot right of way dedication. But anyhow, Pinelands required the houses to be set back 200 feet from the center line of the street. So that's what's depicted on this plan, which is in excess of the zone requirement. But anyway, fully conforming application, no improvements proposed at this time, simply the subdivision of the property. They would be sold to individual buyers to build individual homes, go through the whole plot plan process, comply with RSIS for parking. Of course, we have to have advanced septic systems to get the 1 acre zoning in the RD1 zone. We do have review letters from both the engineer and the planner. We don't take exception to any of the comments outlined therein. Doug just has a couple of technical comments, items to be addressed on the plat, and we would agree to comply with all of those comments. Mr. Peters issued a letter on July 13th where he outlined the application, confirmed that there are no variances required. It was one discrepancy on our plan where the lot width was improperly indicated. 125 feet is the required lot width. Our plan did say 135, frankly, just a drafting error. So these lots do conform with all of the requirements. Pinelands made a condition that only the minimum amount of trees would, as absolutely necessary, would be cleared, and we would agree with that condition as well. And again, we don't take any exception to any of Mr. Peters' comments. We had also submitted the plan to Bureau of Fire Prevention to have an approval letter from them from February 24th of 2026. And we got approval letter from the Traffic Safety Unit in July of 2026. And that pretty much sums up what we're looking to do. Again, fully compliant with all applicable sections of the ordinance.
Mr. Peters?
Well, I get to go first.
It's your day.
Thank you. Graham, building height will comply with the ordinance requirements?
Yes.
What's going on with curbing and sidewalk in the area?
There is none along that street, so the plan indicates contribution to the pedestrian safety fund, but that is entirely up to the board.
You have a note that the survey is a few years old. To the best of your knowledge, have any of the site conditions shown on the old survey been changed?
They have not changed, but we will agree to submit a current survey as a condition of approval.
And how will the subdivision be filed?
Be filed by map.
That's all I have, Madam Chair. Thank you.
Mr. Clee?
Just one quick one. In addition to the payment into the pedestrian safety fund, would the applicant be willing to clean that existing storm drain in front?
I'm sure they would agree to do that as part of the condition of the approval.
Could we include that in the estimate for the pedestrian safety
Put
fund
that on
number? There'll just be another item, a line item for cleaning existing storm drain, X amount of dollars.
If the ordinance allows for that, we would.
I don't think it may not.
It's a pedestrian safety fund ordinance, not a storm drain cleaning
So you don't,
ordinance, so
so you,
I'm going to leave it to the attorneys to tell me if that's okay.
All right, so stipulate to the pedestrian
Cleaning.
safety fund?
And the cleaning of a sewer.
And
Yes.
clean, okay.
thank you.
Anyone from the board? Questions, comments?
And just to be clear, there's no variances, no waivers.
Correct.
Madam Chair, one more.
Oh.
Sorry.
That's fine.
Will the Planlets Commission be issuing a no call-up letter on this subdivision?
Yeah, yes, we had actually obtained one from them for the county approval, but they will also have to issue one for the local planning board approval as well.
In addition to looking at the individual lots as they're developed?
Correct.
Okay, and we can stipulate to that. Right.
That'll be
The
part of our
applicant will stipulate?
resolution.
Yeah.
Yes.
Public now?
I'd like to open this meeting to the public for cross-examination of witnesses only. Sullivan?
Second, DeMarzo.
All in favor?
Aye.
If anyone would like to come,
Yes.
if anyone would like to ask any questions of Mr. McFarland, please come forward now.
Seeing no one come forward, I move to close the public portion of the cross-examination on this application. Sullivan?
Second, DeMarzo.
All in favor?
Aye.
Aye.
Like to summarize?
Just briefly, again, this application has been here before. It's back here in the same form. It's 3 fully conforming lots in the RD1 zone.
In the microphone, please, we're recording.
It's 3 fully conforming lots in the rural development zone. Again, we agree to, to any of the conditions that were set forth today, and we're going to submit. Thank you.
I'll accept a motion. Second public comment.
Yes, I'd like to make a motion to open
General
this
comment.
application. for
General?
public comment.
Mhm. General comments, anyone would like to come forward to make a comment on this application? This is your opportunity.
Seeing no one come forward, I move to close the public comment portion of this application. Sullivan?
Second, DeMarzo.
All in favor?
Aye.
Aye.
I'll accept a motion now.
I'd like to make a motion to approve this application as it is completely conforming. Sullivan?
Second, DeMarzo.
I'll have a roll call vote, please.
Mr. Brezzi.
Yes, based on our professional reports, both of them concur that it's 100% conforming. I vote yes.
Mr. Marzo.
Yes.
Mr. Parks.
Yes.
Mr. Rogers.
Yes.
Mr. Sullivan.
Yes.
Dr. Camp.
Yes, congratulations. Thank you.
Thank you.
All right, now we'll go to Mr. Pfeffer, Block 5101, lots 20 and 21 on Cook and Victoria.
Good evening, everybody. Adam Pfeffer, attorney on behalf of the applicant. What we have this evening before the board is a minor subdivision but really just a lot line adjustment. Again, it's a technical item. We're not creating any new lots. We have two single-family lots that are back-to-back. You'll hear testimony in a minute, but combined, they're approximately 2 acres in size, and we're basically moving the backyard line so that each lot is a little bit more, give or take, an acre. The part where it gets a little technical, one of the properties is currently tied into sewer to the MUA, while the other property is on septic. Jackson Township, there's an ordinance that talks about if we're creating new lots, as a technicality, if we're not tied into sewer, then we have to comply with the R3 standards. Our two properties are right now in the R1 and the R20. Obviously, the R3 standards are much more restrictive. So again, as a technicality, we're creating new lot numbers, but we're not creating any new lots. There's the 2 lots there. If you drove past them, you wouldn't know the difference, but for the backyards are moving. There are some existing variances that go along with that, but again, and we'll go through it, and Mr. Peters' report is correct in stating you have to look at the R3 standards. But I just will ask the board to keep in mind that it's a technicality because we're not really creating that new lot. With that, I ask Mr. Portnoy to get sworn in. We'll get his credentials, accepted as an expert, and then we'll proceed to the reports.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I affirm.
All right. And please state your name and spell your last for the record.
Joseph Portnoy, Portnoy.
All right. And your credentials?
I'm a licensed professional engineer and professional planner in the state of New Jersey. Licensed in good standing. Have a bachelor's and master's degree in civil engineering. I've been before multiple boards, including this board.
Does the board accept the credentials?
Are you a planner tonight, an engineer, or both?
Both.
Thank you.
Thank you.
Yes, we accept. Thank you.
Mr. Portnoy, you heard my opening remarks. If you can, just give the board, confirm some of the information, give a little more technical, and then we can walk through the reports.
Okay. So as noted, we are dealing with 2 lots. Lot 20, which is 431 Cook Road, which is in the R1. Just to orient over here, this is the aerial, Google Earth aerial with the parcel lines. This blue sort of dash line is the zone boundary line. To the left, to the west is the R1, and to the right of this line is the R20. So we have an existing lot, lot 20, block 5105. Lot 20 is 431 Cook Road, which is in the R1, is currently approximately 1.76 acres. It does have an existing variance for lot width and frontage. We are in the R1, 150 feet is required, and it existing is 101.09. The second lot is lot 31, which is 4 Victoria Circle. It's in the R20 zone, and it's approximately 0.29 acres. So this one has existing lot area variance. We are 12,500 square feet. With a lot is 12,500 square feet, and 20,000 square feet is required in the R20 zone. Note these lots are back to back. Most of the rear property line is a line, but the zone boundary does run along that rear property line between the lots. Each lot contains a single family home, and the surrounding uses are also single family residential. So the owner of lot 31, which is a smaller lot, which is to purchase a portion of the rear of lot 20. So they would like to adjust that lot line between the two of them to leave approximately 1.01 acres for lot 20. So that in the R1 zone, 1 acre is typically required. However, there is no public sewer available. So an existing lot is conforming, but in accordance with section 244-47 D, new lots created by subdivision after date of the section shall comply with the R3 zoning standards unless connected to public sewer. So while it is an existing lot and the developed area is all staying within that acre, it technically now, being a subdivision, it's a new lot number, so it falls under that as noted. Lot 20, though, lot 31, I'm sorry, will now actually become conforming, because right now that's deficient in lot area. Now that will become 1.04 acres and will now become a conforming lot. So it is no, it's a technicality. There are no additional variances proposed. The owner of lot 20 will in the future apply for building permits for either a new house or a good pool or whatever they may want to do in the additional backyard. As noted, there is no, they will stay single-family residential. No existing variances are proposed. The variances are required. Let me just go through them. New lot, I guess, lot 20.01 on Cook Road. We're under the R1, we're under R1 for lot area. We are proposed 43,871 square feet, where 43,560 is required for the R1, but under the R3 would be 130,000. The lot width, as noted, was 101.09, where that was existing nonconformity for R1, but as looking at R3 standards is a 200-foot requirement. Lot frontage, similarly, in the R1 that was conforming at 75 feet required. Okay, I'm sorry, the lot frontage is conforming. Front yard setback for the existing house is 54.8, which would be conforming to the 40 foot in the R1, but it's not conforming to 80 feet required in the R3. Side yard setback is existing is 21.4, which is conforming with the 20 feet required in the R1, but is not conforming with the 50 feet required in the R3. Coverages are all compliant. There is also an existing side yard setback variance. There's a shed, I believe, that has existing side yard setback of 10.6, where 20 feet is required in the R1 and 50 feet is required in the R3. And the pool as well, there's existing pool, which is 29.2 feet, which is conforming with the 20 feet in the R1, but not with the 50 feet in the R3. Just know as a R3, as this lot's only about 100 feet wide with the 50-foot wide setbacks, that you cannot comply with anything, with building anything if we would apply R3 standards to this lot.
Mr.
And-
Portnoy?
Yes.
One, you can take a big, deep breath.
Yeah.
Before we
Yeah.
move on to lot 3101, just a correction on new lot 20.01, the lot that fronts on Cook Road, the accessory side yard setback that you spoke about was actually for a garage and not a shed, correct?
I believe so. I could confirm that, but I will accept that, yes.
Okay. The only reason I ask is because there are accessory side yard setback requirements for both garages and sheds, but they're different.
Correct,
So I want
yes.
to make sure that Mr. Shea,
Yes,
under proposed lot 2001, the lot on Cook Road, that the accessory side yard setback is for the existing garage. There is not an existing shed that requires a side yard setback. Correct.
yes, that's correct, yes, I'm sorry.
So now I think we're done with 2001. I apologize for interrupting. Thank you.
Okay, and now moving on to lot 3101. So now this is actually getting larger. So everything complies besides the shed, which was noted, the side yard setback. There's existing shed at 1.7 feet, which is existing nonconformity. And And the pool, there's an existing side setback of 10 feet to the pool, which would not be conforming in either the R20 or R1. I'm sorry, was not compliant in the R20, which requires 15 feet. This lot now would be in two zones. The front portion would be in the R20, but the rear portion would be in the R1 because that zone boundary would be running through that lot. So anything that any improvements in the R1 would need to conform with those R1 requirements. So those are the conditions over there on the lot. So as noted, this is more of a technicality. This is, anyone driving by would not realize that this lot line was adjusted. There's no impact to, to any neighbors or any impact to the zone. There's nothing, nothing that anyone would know about this. It's a technicality with this subdivision, with the lot line adjustment being a subdivision. So now we fall under that section. And now this new lot in the R1 on septic would need to conform with the R3 requirements. So we're seeking variances to continue to apply the R1 standards as they do currently.
So, Mr. Portnoy, I guess my question is, when I drove by both lots the other day, I'm saying to myself, to what end? Like, why? Why is this happening?
Well, again, I think if I can answer.
That'd be fine.
You have two property owners, one who has a oversized lot and if you look, I believe the fence is somewhere close. You can see the area that's disturbed, the brown and the rest is green trees. He doesn't really utilize it. It's underutilized. And you have a property owner who backs up who would like to have a larger property and be more usable. So be able to eventually in the future expand his house or his backyard to that area.
And being that lot is already undersized, he cannot even, do what you can typically do in the R20 zone. So this would actually be correcting that lot size.
Right. So if that person had come, if they didn't have an understanding, right, between the two owners of an agreement to sell the property, if that lot owner, lot 31, would come before the board and ask for and they'd have to come before the board for any expansion, they would have to be required to write buy-sell letters to the contiguous properties. So he would have to do this, and then if the neighboring property owner says, okay, I have excess land, he'd be able, that whole conversation and process would be happening then anyway. But again, so when you say to what end, I understand we're not looking to squeeze in a third lot. They're not trying to get away. It's you have two homeowners who made a deal. I have excess. You're undersized. We could work something out here and sell it, and that's what we're trying to do here: make 2 1 acre plus, a little more than 1 acre size lots back to back.
Mr. Klee, any thoughts? Use the microphone, please. Thank you.
Curb and sidewalk exists, so there's no contribution required. And 2 lots existing and 2 lots are proposed.
Mr. Peters?
In no particular order, Mr. Portnoy, how would the subdivision be filed?
But I think the intent was by map.
By map?
Yes.
Okay, well, it's one or the other, so I'd like to have it so it can be in the resolution. And I guess to our attorneys, I think it should be noted that we're creating what would be referred to as a split zone lot. So new lot 3101 would be located in 2 zones. And again, to the extent that we're not setting precedent or zoning requirements, when the owner of lot 3101 wants to do something in the back, he's going to need to go to the zoning officer, get a permit for a fence or for tree clearing or to put an accessory structure. So this board's making no determination other than to say, by adding lot area from existing lot 20 to proposed lot 3101, we're making the lot larger in size, but we're not commenting on the land or the requirements that are in the R1 zone.
And then we wouldn't want to hear that it's a pre-existing condition. We won't be hearing that, nor will
No,
the zoning board,
No,
correct?
not also. And actually, I've had this exact issue with the Jackson Township zoning board, and I can just tell you how they dealt with it when someone came in. Basically, if the structure was in the front, which would have been R20, they said you have to comply with R20. If you're looking to do something in the back, if you was going to do a pool, expand the pool into the back area of R1, you'd have to comply with the R1 standards. And again, and I'm not telling you that that's what we have to do, but that's how we generally would rule upon it. Anything that's proposed in one area versus the other area, and if they're in both areas, it usually goes to the more restrictive one. But again, they'll deal with that if and when they propose to do something more than just having a larger land.
And this
So
board-
when-
and this
when-
board is not commenting on that.
We're not commenting
No,
on
and
that.
I'm just-
Exactly.
I was just making the comment.
Right. So it would be restricted to residential use. That would be part of the resolution. And it would be a deed condition. It would go along with the deed, residential use only.
Deed condition.
So I think what Madam Chairwoman is saying is, would the applicant stipulate to a deed restriction as to the residential nature of the property?
Right.
As to single-family residential?
And that's their intent. Their intent is to construct they're both owner occupied. Their intent is to just build a new house and more land available.
And it will remain that way. But we want to
Yeah.
put that as a deed restriction in the resolution.
Mr. Shea, you should have one house on each lot. I don't want to see somebody coming in for a flagpole and try to go behind because it's deeper. I
Right.
like it to remain one house on each lot.
That's the intent of one house.
I know what the intent is, but I can see it written in the resolution.
We like it in writing. We're funny that
If we
way.
were going to do that, I would have kept it at 1.7 acres on the larger one.
Right.
Got on that lot. That's not a problem.
Any other comments from the board?
Madam Chair,
Yes,
I just
ma'am.
had a question. You were talking about I think you need a variance for the R3 requirements. Is that,
So as a technicality, because the lot is not tied, only one of the lots is tied into the sewer. So Jackson Township has an ordinance that any new lot created, again, because we're going from 2 to 2, we're not really creating a new physical lot, but there's a new lot number. We technically would have to tie into sewer or comply with the R3 standards, which are much more restrictive and we couldn't comply with. And there's no sewer available on one of the lots, so we couldn't even, if we wanted to tie into it at the moment.
so on Victoria Circle, there's no ability to hook in? Is that what you're saying?
No.
Victoria has sewer. There's no
Cook
sewer
does
on
not.
Cook.
On Cook, okay.
So again, if we had, it would be a much stronger argument on that township, and if we were creating a third lot, and then we'd say, okay, I understand we have to comply with the R3 standards. But I just wanted to point out, there's nothing different that's going to be created here in terms of the lots, but for the lot line.
Anyone else?
Yeah, we can open to the public.
I'd like to make a motion to open to the public cross-examination on this application's witnesses. Sullivan?
Second, DeMarzo?
All in favor?
Aye.
Anyone who would like to ask any questions of Mr. Portnoy at this time, please come forward. We don't bite. Come right up.
Hi, how are you?
Good.
Do I have to give you my
Your name and we'll be sworn in. Your right hand. That's your right.
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes.
All right, please state your name and spell your last for the record.
Sure. Robin Weisselberg, Weissselberg.
Okay, and your address?
126 Piccadilly Drive.
Okay. Now you can cross-examine the witness. Yeah.
So I live on Piccadilly Drive, which runs up that blue line to Cook. I'm one of those houses that are over there. So one question I have is, did everybody from Victoria to Cook on Piccadilly get the letter? Were they sent the letter?
Use the microphone, Mr.
Sorry.
Pfeffer, please.
Sorry, I apologize. We request a certified list from the township of everyone within 200 feet of these lots. We get a list and we send the notice. And yes, I did send notice to everybody on that list.
Do you know how far it went, up to what address on Piccadilly closest to Cook?
The town tax assessor. They usually have
Okay.
a program that gives everybody within 200 feet.
Okay, just because I know, just in speaking to neighbors, that I believe 128 didn't get a letter, which would be that third house
They
with the
did.
pool, and from Cook Inn. And then I believe, I'm not sure exactly which house, but from Victoria Circle, closer.
If you look at the plans, just a second.
Yep.
Mr. Portnoy, you have the plans there in front of you, and it does list who did get letters. And those people,
Well, it lists property owners
Theoretically,
within 200
right.
feet.
Right. And
On
ju-
128.
just as a matter of concern though, so just to be clear, ma'am, so what happens is that you can have personal testimony as to your own knowledge. What you're indicating on the record is what's called hearsay. So you can't have personal knowledge of somebody else's situation. They would have to show up, and it's just one of those.
Well, I just want to know then how far the letters went, just to make sure
Yep.
people had the opportunity, not speaking for them, but
Right.
just to make sure that everyone was aware.
Can we read these?
Could we
I
can,
just-
We have the
you can
list
read
here.
the letter. right.
I can confirm that if it's 128 you're asking, a certified letter was sent to them at 128 Piccadilly Drive. So again, I have the certified receipt that was provided to the township.
Okay, no, just
No
wanted to
problem.
ask.
That's a good question.
Okay.
Yeah.
And it went all the way to that first house on the corner on Piccadilly? I don't know what the address would be all the way down.
It went to everybody that was on the certified
So
list.
just so you know, what happens is that the process for notice in the municipal land use law, the applicant, any applicant has to submit 10 days, at least 10 days prior to the application, certified mailings. And those certified mailings have to be sent in to the board's office for everybody to take a look at. And the certified stamps and are on that evidence. And that's how we determine whether or not the notice is jurisdictionally appropriate, to make sure that like so if they send in the appropriate forms with the certified stampings, we have to assume based upon the post office's stampings that those letters have gone out.
No, I totally
Yeah.
understand that. I just want to know that they were sent. I mean, people cannot pick it up, people can refuse it, but the attempt was made, so I understand that. I just want to know where address did it start at? Did it start at the corner house on the Piccadilly side, on the corner of Victoria and Piccadilly?
Whatever the tax list that was produced by the township for the 200 feet,
We have a
yeah.
map, if you'd like to take a quick look at it. It looks like it went from 118 to 132 Piccadilly. It also appears to be 112 and 114 Piccadilly. And then on Victoria Circle, it went to even numbers from 2 to 10 and the odd numbers from 3 to 7.
Okay.
So I don't know if that helps.
No,
because-
that does help.
But you can certainly take this map and take a look at it.
No, I trust. If that's what you say, I trust. My only really other question was, you said, coming from the street, no one's going to see it. Depending what's going to get cleared, we're all going to see it. So just because you say, oh, if you drive by, no one's going to notice that the lots were split or new lots were made or expanded or shortened. But looking out your back window, being in your yard, I'm assuming if they're going to build a new house, a new structure, who knows how large, well, they just said build a new house as long as there's one house on each lot.
So what happens is that this application before us is just for the boundary line change and the subdivision. So if they wanted to build a new house, they have to file another application for site plan approval. They have to come back and vet the whole thing out. So they don't get to build anything as a result of this. They just get to subdivide the property if the board votes in the affirmative.
There are rules on clearing trees.
Right, and the township gets involved with clearing trees. There's a forester involved. Township professional has to, give the permitting, whole 9 yards. So if you want to actually call the zoning officer and ask her the process via what every applicant has to go through for clearing of trees, she can give you a whole rundown of exactly what the township process is.
Okay.
Yeah.
All right. So then I guess my only concern is just not the fact of driving by and you don't see it. There's a lot, we're gonna see it. So if you split the land and things get cleared for one reason or another, whatever plan is, it isn't, I understand that that's a later issue, but we're gonna see it. So you can't say no one's gonna see it, because we're gonna see it.
So respectfully, either property owner could take out a permit subject to the township's clearing requirements and clear their lot. Nothing to do with this line.
Right, they could, because it's theirs, but they're not changing anything. They own it, it's theirs. But if you're looking to make changes and you're looking to sell off part of it, now you're changing more. So that's just, my point is have to take it into consideration.
You know, if you'd look at that distance between the blue line, that back, because I see Piccadilly, the blue line and the yellow and red line, that buffer will still remain. That's not going to change. That's still going to separate those properties. Nothing within that triangle will be changing for you.
While I understand that, in all spots, it's not as dense as it looks.
Oh, okay,
So,
understood.
you know, you can look out your window and barring winter when things are bare, and you can see straight through. Right now, you can look, and if you look towards this way, it might be really thick and I have no idea what's past it. If you look on this side, nothing grows evenly. You know, and you have all the deer, and they may eat more over here, so it's flatter over there. So it's just not as dense as it looks from an aerial view.
And of
So
course,
while that
anything
buffer's
anything they're going to do there, they will have to get proper authorization to do it.
And then we can come back.
And it will come to you, you'll know it.
Okay. That was just my question. Thank you.
Thank you so
Thank you.
much.
Thank you.
Anyone else like to speak on this, to ask questions of this applicant?
Seeing no one else come forward, I move to close the public cross-examination portion of this application. Sullivan?
Second, DiMarzo.
All in favor?
Aye.
Aye.
Any general comments on this particular application? Please come forward.
I'd like to make a motion to open for the public comment section of this application. Sullivan?
Second, DiMarzo.
All in favor?
Aye.
Aye.
Anyone like to speak on this application?
Seeing no one come forward, I move to close the public cross-examination on this application. Sullivan?
Second, DiMarzo.
Or sorry, public comment on this application.
All in favor?
Aye.
All right.
Just to be clear, this is a confusing one, so let me just put this on record for you guys. So what's happening here is we have a boundary line. So a boundary line change. There's three different ways in which something like this could happen. Number one, if the uses are not permitted and there's a boundary line change, ends up going to the zoning board. That's not the case here. Second way in which townships typically operate and handle these type of situations is that sometimes they'll use the more restrictive zone standards that are involved. Typically that happens via ordinance. We don't have an ordinance on that in this township. How we do it in this township is that if one area is more than 50% in one zone, we use that zone standards. We've done this a couple times over the years, but it's kind of a course of conduct thing that we do in this township. So in this situation, you have the first lot, which is zoned R1, but because of the fact that there's no septic, I believe that we're using the R3 standard. So that would be the first variance relief. It would be based upon the R3 standards, and that's for lot 3101. And then the second situation is the property that's picking up the bulk of the additional property. That standard, or that zone is being changed from R20 to R1. And not changed, but we're using the R1 standards in place of the R20 because the bulk of the property of the new boundary is now in the R1 zone. So all variances that have been requested are existing. So all the structures and everything like that are existing. There's nothing new proposed, right? So when you're taking your vote into consideration, that would be the affirmative vote for both lots having two different standards in varying zones, just to make sure that everybody is clear on what's going on.
So,
Yeah.
I hate to disagree with.
Or did I have that
Yeah,
backwards?
at least on lot 31.01, again, I just want to clarify, I'm not, in theory, the front of the lot, because 31 is currently tied in to sewer, the front of it still goes under the R1 standards. I'm sorry, the R20 standards. The rear of the lot, again, it's just being added in, nothing's being proposed on that side. If they were ever to come back, whatever standards they impose would be fine. But as far as you were saying 50% changing it to a different zone, none of that is occurring. The lot
Well,
is
it's
gonna be
still two
split. It'll
zones,
be in
yeah.
a split zone, and we're not proposing any change. So whenever they come back, however the zoning officer deems what they have to comply with, they'll have to comply with, or they'll be before the board.
Yeah.
I just wanted to, you had 50%
Yep.
rule, I don't believe I haven't seen that.
It becomes a whole new lot.
Right, but just to be clear, the 3101, the one that's picking up the additional property is going to be, this could be a new lot. So there's going to be a split zone
It'll be a
lot.
split zone, correct, and the technicality we're going from 2 lots to 2 lots.
Right.
We're just moving the lot line.
But the zone standards that will be in place from here forward will be that of R1.
Split- I thought it would be a split lot. I believe that's what.
I don't, unless our planner wants to correct me, I think the standard that we use is that if it's greater than 51%, it then becomes, the entire property gets zoned according to what the greater zone is. Unless I'm
I
on,
haven't seen that, and I asked
Peters? Mr. Peters, your thoughts?
Well, all I can give you with regards to that are my thoughts, because I'm not sure that our ordinance has a specific standard, which is why I referenced the zoning officer going forward. It's the zoning officer's determination. If there's case law that wants to be made part of this application, that's wonderful. I offer the applicant's attorney to put that in. Otherwise, it gets done by our zoning officer based upon the ordinances that we have currently, which don't specifically state how to deal with what zone this is in. So yes, you could make the common sense approach. There's an existing house there. The existing house is on sewer. They could make the argument, they could appeal the zoning officer's decision if the zoning officer doesn't agree with them. But you would think, as from a common sense perspective, that the addition of land to an existing 20,000 square foot lot hooked up to sewer would follow those standards.
But that is not for this board to determine, that's
Right,
for the
that's the
zoning
zoning
officer
officer.
to
Yeah.
determine.
Correct, and that's
Right.
my only
We're not
clarification
going
of
there.
Mr.
I
Shea's
think I was overthinking
I
it.
wasn't,
Right.
we weren't asking to pick it, so we're just saying it'll be the zoning officer's decision. We're just looking to move the line. Otherwise, I always agree with what Mr. Shea says.
All right. Any other comments on this application? Want to summarize for us, Mr.?
Yes,
Pfeffer?
thank you again. I think I'll be very brief. Application is to move the lot line between the 2 neighboring properties. We'll create 2 a little bit more than 1 acre property lots. They'll comply with the zoning officer and the zoning standards as they come into play with what they're going to be proposing. But as of now, you have 2 single-family houses that are going to be on 2 single-family lots. And we agree to the other conditions that the board had asked for. And we'd ask that the board take a vote as an approval.
I'll look for a motion.
I'd like to make a motion to approve this application. Sullivan?
Do we also need to vote on the variance?
So the vote would be encompassing the variances. You don't really want to separately, separate them. So if you want to deliberate upon the variances, then you're more than welcome to. So I'll let Mr. Sullivan.
Withdraw yours.
I withdraw my
So do we want to discuss,
motion.
Ms. Marzo, the variances? That didn't exist previously.
No, I'm okay with it. I just wanted to make sure that
will
we're
encompass.
clear. Mhm.
And that's on me. I should have made that clear. So I'd like to make a motion to approve this application with variances. Sullivan?
Second, Demarzo.
We'll have a roll call vote, please.
Mr. Brezzi,
I want to note that most of these variances are pre-existing non-conforming. So there's nothing you can do with them anyway, so I vote yes, it's only moving a lot line.
Mr. Marzo,
Yes.
Mr. Parks,
Yes.
Mr. Rogers,
Yes.
Mr. Sullivan,
Yes.
Dr. Campbell.
Knowing that any changes forthcoming will be appropriately handled by the appropriate boards, I vote yes.
Thank you so much. Have a
Thank
good
you.
evening.
Thank you. Have a good evening.
Following the IBC regulations for facility height.
But this is.
Yeah. Good evening, Ms. Jennings.
Good evening. For the record, I'm Donna Jennings from the law firm of Willens, Goldman, and Spitzer on behalf of the applicant. As the board is aware, the applicant is here this evening seeking preliminary and final major site plan approval with no variances to construct a two-story building with a basement consisting of approximately 32,955 gross square feet to be used as a child care center and related site improvements on approximately 1.92 acre lot located at 33 South New Prospect Road and designated as Block 5902, Lot 53 on the Township's tax maps. In addition, the applicant proposes to remove the existing single-family residence and commercial building along with related accessory structures to construct the proposed child care center on the property. The property is located in the neighborhood commercial zone, a non-residential zoning district. Under the state statute NJSA 4055D-66.6, child care centers are permitted uses in all non-residential zoning districts in the state. Accordingly, because the NC zone is a non-residential zoning district, the proposed child care center is a permitted use and is not subject to the conditional use standards otherwise applicable within the NC zone. Although no bulk variances are required, the applicant does require several design waivers with respect to one, the minimum length of entrance drives, where 100 feet is required and 40 feet is proposed. Two, the minimum length of exit drives, where 60 feet is required and 43 feet is proposed. Three, no parking stalls shall utilize required major circulation drive as parking access aisles, whereas the parking accesses the main circulation drive. And four, no structure shall be permitted within the buffer area, whereas a retaining wall is proposed within same. The record will reflect that the waivers may be reasonably granted because they present a better planning alternative and safer design. In support of the application, the applicant will rely on the following witnesses. Ellie Halpert, the site engineer sitting to my left, Naftali Gutt, the architect, and John Ray, our traffic engineer. As a matter of record keeping, the applicant is in receipt of the following review letters from the board's professionals. The board engineer review letter dated July 29th, 2026. The board planner review letter dated July 30th, 2026. And the tree specialist review memo dated August 3rd, 2026. So with that, we'd like to have Mr. Halpert sworn in and we can begin our application.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, please state your name and spell your last for the record.
Eric Halpert, Halpert, licensed professional engineer and planner in the state of New Jersey. I have testified before multiple boards, including this board, multiple times, and these plans were prepared under my supervision.
And Mr. Halpert, you're testifying as both a planner and an engineer?
Both a planner and an engineer.
Thank you. We accept your credentials.
Thank you.
So if you could, Mr. Halpert, if you're going to use any exhibits, if we can identify them for the record, and if you could start by describing the existing site and the area around the site.
Anthony, could you go to the second sheet of this set? Can you mark this aerial exhibit as Exhibit A1? The site is located along South New Prospect Road. It is located in the NC zone. The NC zone is, as the name suggests, neighborhood commercial pockets throughout the township of areas either at intersections, close to intersections, for neighborhood commercial uses. The property is surrounded by residential zones and residential development, a combination of R1 zone and R15 zone. The applicant is proposing to construct a daycare. The existing property is currently improved, as mentioned a moment ago, with a not currently in use animal hospital and a single-family residence and other accessory structures with parking area. The proposal is to demolish the existing structures and improvements and to install the applicant's proposed improvements that I will go through shortly. I'll go through first the statement of operations and also discuss the conditional use requirements that would govern a child daycare and other properties that are non-commercial, and discuss how it is different. The proposed improvements differ from the conditional use requirements. The applicant seeks to construct a child care center with a basement floor and 2 stories above ground, encompassing approximately 32,955 gross square feet, to provide services to children ranging in age from infant through 5 years old. The applicant proposes indoor play area and outdoor play area. There will be approximately 53 staff members, a maximum of 400 children, 23 classrooms. Classrooms range from 12 children to 22 children. There are lunch rooms proposed for the children. Food will be provided via delivery, and I'll go through the site plan. There will be no food preparation on the premises. However, lunch will be served to the children. The hours of operation will occur between 8:30 and 4:15 p.m. with staggered start times and pickup times to accommodate different people's schedules. Between 8:30 and 9:15 a.m. will be the morning drop-off, typically at 3 separate slots, 8:30, 8:45, approximately 9:15. Pickup will be between 3:45 and 4:15. There will be no activities in the evening or on the weekends. To administer pickup and drop-off, and as will be shown on the plan, parents will pull into the parking spots in the front of the building and enter the daycare to pick up or drop off their children. Deliveries would include daily deliveries of lunch and every 2 weeks or so of paper goods, toiletries, personal goods for the children. A typical delivery vehicle would be a large van or a small box truck.
Can you just confirm that there'll be no buses coming to the site?
There are no buses coming to the site. Loading and unloading of the children is via parent drop-off, where the parents will be pulling into extra parking spaces designated specifically for drop-off and pickup of the children.
Mr. Ruzzi has a question?
Yes.
Microphone?
Room at one time as something to 23. What was your numbers that you gave?
The architect will go through the plan, but they're, depending on the age, the number of children per classroom ranges from 12 to 22.
In the statement of operations, I'm reading 15 to 18. I just want to get it clarified.
That will be corrected. The architect will go through the plan.
Thank you.
Madam Chair, I also have a question on the statement of operations. You indicated, and well, the one that I have in front of me says that it's from newborn to 4 years old. Is it actually newborn to 5 years old?
It is 5 years old. I'm sorry.
So
years old.
you're amending your statement of operations?
Yes. And this is on the architect plan, indicates which classrooms are designated for which age children.
And what was the total students per classroom again?
22.
They range from 12 to 22.
Are we going to have testimony on statement of operations by an independent witness or?
No, Mr. Halpert was
Ms.
handling
Halbert?
that.
Okay, gotcha.
Then it's good we're asking these questions at this time. And you've stipulated Monday through Friday.
Correct.
Correct. There are no weekend or weeknight.
And there will be no after-school daycare.
Nothing beyond the 4:15 pickup time.
And there will be no other uses for this facility, no rentals or anything of that
Correct.
nature?
This is for a daycare, and the applicant is a daycare operator.
Okay, thank you.
And is familiar with the state licensing and operates daycares.
One question. I didn't clearly hear you. Did you say there's no buses?
Correct. There are no.
Parents?
Correct. There are no buses.
Okay. And they're all going to come at the same time?
The drop-off and pickoff will be staggered. They will come generally between 8:30 and 9:15 with 3 designated.
That's not significant staggering. You're going to have a lot of cars in a 45-minute period, say an hour.
Correct.
What's the basis for the staggering? Is it going to be based on age of children or location, or how would you know who would come and when?
The basis is generally the customer desire based on their own schedule. So the facility has different drop-off and pickup times, and each individual parent will be picking a slot that works with their schedule when they need to get to work, where they live, what works with their schedule.
With 400 children, that seems like a lot. So how many would you anticipate, since is there already a daycare facility? I think there is a Cocoon in Lakewood already.
The applicant does operate a daycare facility and is therefore familiar with the operations of a facility, yes.
So what would the staggering look like for 400 students?
In terms of actual traffic, I think it would be best to allow the traffic expert to discuss what that would look like, level of service, I think is what you are looking for. I think that would be best to leave for the traffic experts.
Okay, thank you.
Please continue. Thank you.
The applicant is proposing there are indoor play areas and a smaller outdoor play area. And I will go through, before going through the plan, just to discuss some of the differences between the conditional use and the current proposal and the ability for the site to accommodate the proposal. The conditional use requirement, which has been determined does not apply and is indicated as for reference only in the board planner letter, required 100 square feet of outdoor space per rated building capacity. The applicant is complying with, over here, the state statute, which does not provide a specific requirement per rated building capacity. Rather, the state statute provides for 35 square feet for intended use of children at a time. The applicant is proposing a 1397 square foot outdoor play area, which would accommodate approximately 30 children at a time, which would be 1 to 2 classrooms at a time, depending on the type of classroom. That would be in addition to indoor play areas that the architect will demonstrate within the building. There are 2 indoor play areas. Additionally, the conditional use requirement is for interior facilities that are used should not be more than a half story above or below. The applicant is proposing a basement and 2 stories above. The applicant did work with the unique topography of the property, where the slope, the grade rises steeply toward the back, as I'm sure the board members saw upon their site visit. So in a way that the children are making use of the basement, but there are 2 ramps that need to change grade of approximately 3 to 3.5 feet to get outside without needing any steps. So the applicant is proposing 2, I'm talking in terms of operations, we'll go through the actual plan, but just in terms of the conditional use, the basement is being utilized and there is a 3 to 3.5 grade difference from the entrance to where the ramp will come outside the building.
Mr. Halpern,
Yes.
you said there would be staggered play areas times outside with 30 children at a time.
Correct.
How long would that period be?
The play time would be approximately 20 minutes at a time.
Because I'm looking at, I'm doing my math here on, there's an 8-hour day. There's an organizational time drop-off in the morning, which reduces that from 8 hours. You've got 400 children. There
are 23
you'd almost need a 10-hour day here, you know?
There are 23 classrooms, and the applicant is providing outdoor area where there is no state statute requirement to provide outdoor area greater than 350 square feet. The applicant will be utilizing both the indoor and the outdoor area. So between both the indoor and the outdoor area, the applicant is going to have.
And I guess that's weather dependent.
Certainly it's weather dependent. Likely infants won't be utilizing too much the outdoor area, but the applicant is looking to provide, to comply with the state licensing laws and to provide a various play options. But correct, not necessarily will all children be utilizing the outdoor area in one day.
The architect will go through the floor plans because there is about 750 square feet playroom on every floor. So we have that in addition to the outdoor.
Thank you.
I apologize for interrupting. Ms. Jennings, I appreciate Mr. Halpert's testimony about complying with the state regulatory requirements. At some point, whether it's him, yourself, the project architect, could we spell out what that standard is so that it can be in the resolution, so that as part of resolution compliance, someone gets whatever they need to verify these standards? Because while I don't discount sworn testimony, it's simply not part of the record just for board members of the public to digest what that standard that was referred to is. So while you might understand it, I might understand it, just for the purposes of making a record that says we're going to comply with those standards, if someone could specify them and then put them in as part of the record.
I can
that'd
give
be
you the
helpful.
regulation right now. It's
Thank you.
NJAC 3A:52-5.4A 7I. It's called outdoor space requirements for children over the age of 10 months. So the young infants don't require any outdoor space.
Thank you for that specific. The general standards that Mr. Halper keeps referring to, the state standards.
That is the state standard.
Must cover
That's
more
for
than just
license.
recreational area. There is a state standard for the entire project, not just the recreational area.
Okay, understood.
Yes,
Okay, we'll look at that.
thank you.
Yeah.
Mr. Peters, anything else there? Thank you. Thank you, Mr. Halpern. You may continue.
Okay, I will go through the plan.
Thank you.
Anthony, can you please pull up the site plan? That's a different file. This is a different file. This is the third page of this file. Could you pull up the civil set? Thank you. Can you go please to page 3? Thank you. The applicant is proposing to construct a daycare center with a basement and 2 stories, as was discussed before discussing the on-site improvements. I like going through first outward and then in as part of the application because the site is situated along South New Prospect Road, which is a county roadway. The applicant is required and did submit to the county for site plan approval and received comments. What is depicted upon on the plan are complying with, generally complying with what the county is looking for. As the board is aware, the county is in the process of restriping South New Prospect Road into a 3-lane section per their master plan. Those improvements have not reached yet this section of roadway. As part of this application and approval, the county is requiring the applicant to stripe in front of the property and with a taper both before the property and after the property, the 3-way section. So upon the installation of the site of the improvements that are proposed, the applicant will be providing in front of the roadway the 3-lane section master plan per the county master plan with that center 2-way left turn lane. The county requested that the taper for the 3-way section begin beyond marginal to the east of the property. Additionally, as part of the offsite, as part of the outside agency approvals, the property is currently on septic. There is sewer nearby and within Marginal Road, and the applicant applied to JTMUA to connect the site to the public sewer system and received preliminary approval. And the applicant will continue to.
I think Mr. Brezzi has a question concerning that.
Has the MUA indicated they have enough flow for you to hook to that line?
The MUA has. We have received preliminary approval. That is when they.
They have enough flow to supply that line. They're not overcapacitated there.
Correct. This section, there are different sections of their system.
Correct.
And this section of the township is generally better capable of handling more flow.
I would not use the term generally can do that because they're having problems out there. But you said they committed to you on this and it's in writing?
We have received a approval from the JTMUA, a preliminary approval. They require applicants to go through 3 steps: preliminary, tentative, and final. And preliminary is where they give the general overall approval that the application can be accommodated.
Now, if you don't get a final approval for them, do you come back in front of us?
These improvements can only be proposed with sewer. So the
That's what I'm trying to
applicant
say.
needs to connect to sewer. If the applicant would only be able to propose a septic system, the application would not work.
So simply stated, if you can't get the sewer service, you cannot do the application.
That is correct.
Thank you.
And that will be part of the resolution.
That's part, yes.
I think that's part of every one of your resolutions to get outside agency approvals, which we will do here as well.
Great, thank you.
And physically, the project would not work without the sewer connection. And that was one of the first pieces we reached out to JTMUA to confirm. Looking on the site, the applicant is proposing 2 one-way drives, a one-way drive for ingress along the easterly side of the property, and a bifurcated left turnout and right turnout egress along the western side of the property. The applicant is proposing a full movement around the building, 86 physical parking spaces. 6 of those parking spaces will be EV-ready parking spaces, which would be considered to be providing 92 spaces. Per the township ordinance, 66 spaces are provided, 1 per 500 square feet of gross floor area. There are 53 staff members, and the applicant will be utilizing the excess parking spaces for, as mentioned earlier, for the parent drop-off and pickup.
I'd bet money Mr. Brezzi has questions about those egresses and ingresses.
Well, I have more from Mr. Peters. Ready? On the egress coming in, if you look at the first parking space there, it's just at the mouth of where they're coming in. That should be eliminated there. I mean, somebody backing out be hitting the incoming traffic.
Mr. Ray will be providing testimony regarding traffic.
I mean, we are significantly overparked, so
No, I'm
you
just
can
saying-
certainly lose a parking space if
I
that's
understand.
needed.
I'm just looking at the safety point that if you look
Understood.
at the curve coming in, the car's backing out right there. It's actually
Yeah.
waiting to happen.
We'll have Mr. Ray address that, but if
Yeah.
everyone feels that.
He
it
can
has
look
to be
at the,
eliminated.
he can look at the same situation on the other side.
I too, right. I didn't get there yet. I was on one
But
side.
you didn't get there yet. All right. And I think there are some, I have some major concerns about Marginal Road. That's a big opportunity for stopping and lining up. That worries the heck out of me as far as I lived on that area for 30 years. I know that roadway extremely well, and Marginal is an interesting road, unusual. I certainly would not want to see that used as a lining up area. I don't know, Mr. Brezzi, could the township maybe consider the residents have a right to park there. I'm talking about stopping and standing. Maybe a stopping and
Stacking cars there
standing.
could be a problem, especially where
Stacking
Marginal
cars
is.
might be a major problem on Marginal.
Okay,
Okay?
we don't have an issue with that, and
Great.
really more traffic, so we'll have Mr. Ray
Understood.
discuss that.
Just as long as we were talking about that area.
Terrible name for a road, too.
Marginal, well, you know, if you're used to other towns that in the south, they do that. They call those side roads marginal roads. So that's why it was called that when they built the Brookwoods.
Just to be clear with stipulation-wise, so the applicant's going to be agreeing to putting a no stacking sign or something to that effect?
No stopping, no standing.
No stopping or standing, and can apply to the township for
Correct.
an ordinance.
Just so we're clear, that approval has to come from the governing body because it's in a public right-of-way.
Exactly right, and that's why I asked Mr. Brezzi.
And the applicant agrees to make the request.
Mr. Shea, just for a legal opinion, would there also be a possibility of signs that say restricted for non-resident parking?
restrictive for non-resident parking?
I think we'll have Mr. Brezzi discuss that with the council.
Yeah.
Signage, the way we want that signage. Thank you.
The applicant is proposing parking and drive areas throughout the site. The applicant is proposing a refuse storage area for both solid waste and recyclables. It would be anticipated that twice weekly pickup should suffice. This will be serviced by private hauler and can be adjusted as needed. The applicant is proposing a loading area as discussed previously. The applicant will be providing food for the children and will be receiving daily deliveries of food, typically in a large van, in addition to paper goods, office supplies, replenishments, or personal supplies, toiletries for the children, which would be more once every several weeks, again, via a Amazon or UPS type large van or small box truck. And a 12 by 35 loading area should suffice for that type of delivery. The applicant previously submitted the previous site plan that was previously submitted to the board prior to where there was no driveway in the rear, and received the approval from the fire official in terms of the site plan. There are comments from the fire official regarding hydrant location, fire connection. The applicant will be required to resubmit the plan to the fire official for the approval, and this proposed revision to the plan improves upon circulation by providing the circulation around the building throughout the site.
Mr. Halpert, did you get a review from the fire official for this revised layout?
To be clear, we did not receive a review letter for this revised
Okay,
layout,
thank you.
and we did not.
But that will be forthcoming and required.
That will be required because the fire official has comments and we need to resubmit plans to the fire official. I was pointing out that the revision is an improvement upon the previous plan in terms of circulation for fire. The applicant proposes, in terms of the architect will go through the building in terms of the site, as mentioned previously. Anthony, could you zoom into the building, to this area a little bit more? Thank you. The applicant, as mentioned previously, is proposing several means of egress. This area and this area are means of egress from the basement floor, approximately 3 to 3.5 feet of rise from the basement level to the outside will service the basement means of egress. An additional ramp, again, because of the unique topography of the site, the basement floor is approximately 3.5 feet below grade. The first floor is approximately 3.5 feet above grade, and a ramp will provide a means of egress as well for the first floor, in addition to other means of ingress and egress with steps. Anthony, could you go to the next page, please? And could you zoom out to show the extent? The applicant is proposing stormwater improvements to comply with NJ DEP stormwater regulations, a combination of surface basin and subsurface basin, inlets throughout the site will direct surface runoff to the surface basin, subsequently to the subsurface basin in order to comply with the NJDEP stormwater regulations.
Will that area be fenced?
The area of the surface basin above ground will be fenced with a 4-foot high chain link fence.
Thank you.
The applicant, Anthony, could you go to the next page? Could you go 2 more pages?
We can use that as a reminder to silence your phones, ladies and gentlemen, please.
The applicant is proposing landscaping for this size building of 32,955 square feet. A 25-foot buffer is required. The applicant is proposing a 25-foot buffer. There is a short 1.5 foot tall landscape wall that is proposed to ease the grading. I do believe that is justifiable. It is a short wall. The grading in the existing conditions is steep, and this is a better way to ease the grading. It can be accomplished without the wall, with the parking area being sloped slightly more, but I do believe a 1.5 foot wall within a 25-foot buffer and referred to as a landscape wall, a short wall, would be acceptable. The applicant did receive a letter today from the tree expert, and I had a brief call with the tree experts subsequent to the letter, and we are able and willing to work with the applicant to provide more various species and to work with the forester to comply with the ordinance and provide buffering and screening along the side and the rear, and I will discuss the front as well.
Just I want to state for the record, though, that the tree specialist review letter actually dated August 4th for tomorrow, not today. So just so the record's clear, that's a letter we should be relying on.
We did receive the letter this afternoon, and I had a brief call with Sherry, and we work well together, and we are able to comply with her comments. I will go through the review letter shortly. The applicant is proposing lighting as well. And I will go through the review letters.
I don't know if you actually addressed parking. Did you go through the parking calcs?
The parking calculation for child daycare in the Jackson Township ordinance is 1 space per 500 square feet. And as mentioned, which would come to a total of 66. And as mentioned previously, the applicant is oversupplying the parking in order to provide the loading and unloading areas, extra parking spaces for parents to pull in, drop off, come out of their vehicle, bring their children in. And again, there is no busing or van or any other means of providing transportation for the children except for the parents bringing their children.
So there would be no personnel from the school coming out to pick up a child from a vehicle. The parent must park the car, take the children from the car into the school. No personnel would come out and pick up the child. Because I'm concerned about lining up, that's an issue.
The parent will pull in, will need to be buzzed in terms of will need to be buzzed in and will bring their child in.
Fine, thank you.
To go through the comments from the board planner dated July 30th regarding the comment on page number 7, comment 2 regarding the maximum height. The applicant seeks no variance from maximum height. The average grade can be adjusted, and the actual maximum height of the top floor will be lowered as needed for those 6 inches. The applicant seeks no variance, and a couple inches can be shaved from the building height via some grading, and the applicant will lower, and the architect will discuss the height of the highest floor in order to ensure that the building height is not greater than 35 feet. The applicant, as discussed, is providing a site to accommodate 400 children with approximately 53 staff members in the neighborhood commercial zone, as mentioned per the state statute allowing for daycares within commercial zones. The applicant is providing a 4-foot chain link fence around. Anthony, could you please go to the 3rd page of the set? The play area that was mentioned previously is across from the building and across the driveway, and the applicant will place pavement markings and stop signs to ensure safety. The children will always be escorted with the staff members, but in addition to that, the applicant agrees to provide both pavement markings and stop sign for traffic to always stop.
Crosswalk.
And crosswalk for safe passage to the.
You might consider signage on that corner where there's a turn, slow down or some kind of marking to indicate that there are children crossing there.
Yes, the applicant agrees to place pavement markings to stop.
Madam Chair, you have a chain link fence around that. Can't you make it a different type of fence?
A vinyl fence. You're looking for a solid fence. The applicant would agree to provide a more aesthetic, a solid fence. Yes.
Was that a visibility issue, though?
That's what I was thinking. Like, what if a kid climbed over the fence and nobody would know? I would keep it chain link.
The people watching the children from the inside of that area would have difficulties seeing to the outside of that area. Where with chain link, there's visibility on both sides. So there's observation from the street and the school and the driveway to the play area.
I'm concerned about somebody running into that chain link fence because you're in the parking lot. So.
The plastic,
Well, maybe we could put
plastic
some-
fence won't do any better.
No, but maybe we could put some bollards around the driveway entrances in and out. Maybe that would be helpful.
Bollards on the, because of where the driveway is coming in and around, right at that curve area might be good to have bollards. So safety, but to have
Safety.
chain link, then you can see.
Safety first. While I don't often recommend the board debate or negotiate issues of design waivers or variances with the applicant. In this case, I think the point that Mr. Marzo was making had to do with safety. And so certainly we can do something that doesn't look industrial, okay? That provides visual safety. So if we put up the concrete filled steel bollards, similar to what you might see in front of a Wawa gas and convenience center, something to that end. And then behind that, put chain link fence so that the kids don't get out. Then we may have accomplished both tasks that were set forth.
I think that would be an excellent solution.
How do you feel about that, Mr. Marzo?
That's fine.
Good. Thank you. Good suggestion.
The applicant is proposing signs, only building signage less than 80 square feet.
So there's no waiver on signage.
The applicant seeks no waiver on signage.
We will make sure that there will be monument signs for the sake of the police and fire departments.
Yes.
Yeah.
Thank you.
Yes. I will leave most of the traffic comments for the traffic expert. There is one comment regarding the slope of the egress drive, and the applicant is able to lower that 12% to 10% on the egress drive.
That was comment number 9 on page 9.
Correct. The regarding the landscaping, the applicant will work with the landscape, with the tree expert regarding the frontage of the property. There is an approximately 3-foot grade change. The applicant is able, I did take a look at the grading. The applicant is able to berm up a bit, not the entire 3 feet before coming down, but the applicant would be able to create a berm immediately beyond the surface basin of approximately 2 feet beyond the surface basin. So there is not that great a difference in grade change, and we'll work with the tree expert to provide sufficient buffering within the frontage in addition to the side and the rear.
So that's addressing comment E2 at page 9.
Yes.
The applicant would not need a waiver from that comment.
The applicant would not be seeking a waiver from providing the buffering and the screening. The applicant will will adjust lighting to ensure that there is no spillage into the adjacent properties, and will remove stormwater from the lighting plan for for a clearer plan.
And regarding lighting, since the property is only going to be used until 4:30, which means in the winter, maybe 5 o'clock for the staff to leave, could there be a shut-off time with nothing but security lighting after 8 o'clock?
The applicant would agree to that. Again, there are no activities.
That way, the
proposed.
neighbors would not have to be concerned about lighting in the evenings.
The activities are only for daytime, yes.
Correct,
The
but
applicant
it's still
would agree.
at 4 o'clock in the winter, it's dark.
And that's why there is lighting proposed.
Right.
But the
But
applicant would
nothing but
agree.
security lighting after 8 PM.
Yes, the applicant would wish to have on security lighting throughout the night, but nothing more than that.
Agreed.
Just
You said 8 PM?
8.
8 PM?
8 p.m.
Yeah.
regarding the general impact of the project, the site will bring some more noise from the vehicles entering and exiting and the children playing. However, it should be noted that, again, the activities are all during the daytime hours. There is nothing on the weekend or on the weekend or on weeknights, and therefore these impacts that are unavoidable are not great impacts. And in terms of noise, more noise would likely be coming from the vehicles along the roadway than from the added extra vehicles from the site. I'll go through the board engineer. Some of the
Mr. Peters,
comments-
did you have anything else from a planning perspective, as long as we've just finished that section?
Not as it relates to the letter, but before we're done with his direct, I have a couple of questions.
Fine. Mr. Clee, we're up to you now.
And, to go through the board engineer's letter dated July 29th, 2026, some of the comments are similar regarding soil removal. Likely, the project will require soil removal and will be required and will apply for a permit per chapter 244-166. The applicant is proposing 66 parking spaces, which would be the equivalent of 92 with the EV spaces. The applicant agrees to address the stormwater comments detailed in the review letter. Regarding the off-site lighting, a note will be placed on the plan indicating that the site lighting will be adjusted as may be directed by the township engineer. The applicant will be, again, complying with the buffering and screening and will provide the safety island shrub planting. A 25-foot buffer is provided. A note will be placed on the plan to indicate the loading zone area. The applicant is able to comply with the technical revisions and has made the outside agency submissions and has received comments from Ocean County Planning Board, Ocean County Soil Conservation District, Jackson Township MUA, Jackson Township Bureau of Fire Prevention, Environmental Commission, traffic safety, tree removal, recycling. The applicant typically will do as part of resolution compliance. That would conclude my direct testimony.
Mr. Clay, before we take a break, do you have anything to comment about Mr. Halpern's response to your letter?
Not in response to my letter.
Not at this time. All right. I'd like a motion to take a 10-minute recess, please.
If-
We've already been meeting for several hours.
Can I just address a couple of?
Please.
Okay. So I'll be quick and then we can take a recess. So just because of the fact that the conditions are no longer in the mix, I kind of went on a deep dive as to the state standards, right? Because a lot of these things now default to state standards, one of which we addressed via recreational area use, right? So another one I just want to touch on is NJAC 3A:52-5.3. I think is M1. Children under 2.5 years old have to be on the first floor. So I just want to make sure that the applicant's going to be stipulating to that. You know, we don't really have a breakdown of how many, the age range of the children, you know, per infant of 4 or 5 years old, that wasn't broken down in the statement of operations, which leads me to my next NJAC 3A:52-4.3, the staffing child ratio. And this is kind of where it gets into the employment wise. I think the applicant may want to put more information on the record. Anything under, any child under 18 has got to be a 1-to-4 ratio. 18 to 2.5 has got to be 1-to-6. 2.5 to 4 has got to be 1-to-10.
Yeah,
then
but
it goes-
respectfully, we're getting into licensing, which is really beyond the jurisdiction of the board.
As long as the applicant is going to,
We're going to comply with the state regulation we have
right, the
to.
state, you know,
Yes.
and that's factored into the employees that are going to be coming to the site.
Correct, that's why there's
Yeah.
so many employees.
And then just the parking we have, how many parking spots do we have?
92 with you.
We have
There are
92. Physically versus,
86 physically.
86 physically.
Which per this ordinance is considered 92 because of the EV.
And 66 are required.
right, but then we have 53 staff members, each one may be taking up one space, correct?
That is correct. Typically, some staff members will carpool, but there are 53 staff members, and they could take up.
Right, so if the applicant just wants to reconcile how there's going to be 400 kids worth of cars coming in and 53 spots may be taken out of the equation, you know, I don't know if the applicant wants to consider some kind of staggered drop-off plan,
Well,
something to that
we've
effect.
already indicated there is a staggered, and most of the staff people's children actually go to the school. So they'll be bringing their children with them.
But just for reconciliation purposes, if the
Sure.
applicant wants to put more testimony.
We'll
on
have
it.
Mr. Ray get into that during his testimony.
That is it.
We'll take a motion to take a 10-minute recess. We've been meeting since 6:30, and we've had two others before you, so.
So moved, Sullivan.
We need a second.
Second, DiMarzo.
All in favor?
Aye.
All right, 10 minutes means 10 minutes, ladies and gentlemen.
I'd like to make a motion to reopen the meeting. Sullivan?
Second, DeMarzo.
All in favor?
Aye.
All right.
Okay, so I think we finished the direct of Mr. Halpert, and I'm not sure if there were additional questions.
Are there additional questions from the professionals for Mr. Halpern?
Just a couple. The staggered drop-off times, how is that ensured or guaranteed or like it's customer driven? But what happens if the first customers all want the early drop-off?
The applicant is an operator, and typically there are varying times that are desired.
And how big is the largest delivery truck we anticipate?
It would be a small box truck would be.
So the
Large van, small box truck.
So the 12-foot by 35-foot loading areas
Should suffice.
there's an
Into the microphone, please. Thank you.
and there's an excess of parking. So if the board felt they needed to enlarge the rec area or provide for additional entrance drive length, there's the ability to do that.
The applicant could lose 1 or 2 spaces, but the applicant is seeking to keep that excess parking area for the unloading of the children.
Okay, thank you.
Madam Chair, I had an opportunity during the break to speak to Mr. Halpert with regards to the building access points and the grading associated with them. And I was wondering if I could ask Mr. Halpert to just explain to the board what the grading to the access points on the sides of the building will look like and what will be provided in terms of safety for those areas.
Thank you, Mr. Halpern. You go
Sure.
ahead. Thank
Yes.
you.
Anthony, could you zoom into the building so we have a better view of the building itself and the ramps? I'm sorry, could you go to the next page which shows the grading and do that? Could you do zoom in a little bit more? Okay. So for example, to discuss the basement and the first floor. So the basement elevation is shown as 145.15.
And maybe I could ask this question. Is it the intent of this design, and I know you're not the architect, that all drop-offs are meant to occur along the front of the building? And that these access points on either side are not meant to be drop-off locations?
Correct. Those access points are meant for emergency, are not meant for the drop-off.
Thank you. So generally speaking, people would drive in wherever they park. They would walk in the southerly entrance or the entrance closest to South New Prospect Road. We expect 99% of folks to walk their children through those doors.
Yeah, that is correct.
And that's
Yes.
pretty much at grade. There's not a lot of grade change. It's not real steep, anything like that.
Correct.
Now, could you explain the grade changes and the safety provisions for the accesses on each side of the building, please?
Certainly. Along the side of the building, so these access points are servicing the basement floor. The purpose is to provide access without the need for steps, for cribs, and that is both of these doorways that the board is looking at are located within the basement floor, and a child can go out of the door and out up the ramp. The grade for the basement level is noted as 145.15. The grade where the child comes out is, as noted earlier, approximately 3.5 feet higher. Exactly at where the the access point is, the floor is 145.15. The outside grade is approximately 151.5, so meaning that it is the access point is located approximately 6 feet below grade. And in order to make sure that there is no safety issue, similar to any basement wall, a rail will be placed on top of the walls to ensure that nobody will be jumping over down
Good plan.
into the basement floor area. Similar, could you scroll so that we could see the top higher on the page? Similar, as mentioned earlier, this ramp is servicing the first floor as noted on the plan, slightly obscured, but the first floor is approximately 157.65, and the grade over here is approximately 152.5. And again, there is a wall that would be higher. The access point is going to be higher than the area outside the access point, and a wall will be placed in order to prevent, a rail will be placed in order to prevent anybody from jumping over or falling over. Similar to any basement access with a wall where a rail is required to make sure that people walking along the upper portion are not, have no safety hazard.
Do you think it should be a double rail, something adult size, and then another rail below that to accommodate smaller? So you'd want a double,
A 3-rail.
yeah,
Kind of like you have a post and rail fence is normally 2 rails, perhaps 3 rails. I
correct,
think
perhaps
we could-
3 rails, because that would really impinge upon a child falling through or walking through. So is that what you had in mind, Mr. Peters?
Yes, it's somewhere in between the site engineer to set the grades and the building architect to make it building compliant. Somewhere in there was the answer. I just thought it was important because of the grade change of 12 feet between each of the floors. If I asked the architect and he says, well, I'm not doing the grading, I just wanted to start the conversation with Mr. Halpert. and if
Engineering.
necessary, have the architect, the site architect confirm that that's in fact what they're going to do to provide safety for the users of the building.
All right, so we'll stipulate that, 3 rails.
Yes.
Understood.
The applicant stipulates the 3-rail system?
Yes.
And the last question I had for Mr. Halpert, you talked about the county improvements for striping. I normally wait for Mr. Ray to ask this question, but is it anticipated by the applicant or you that these striping improvements will be installed prior to the opening of the building?
Yes, as part of the county approval letter, the county is requiring this 3-section striping to be installed as part of the county approval.
Prior to anyone occupying the
Prior
building.
to CO, yes.
Thank you, that was all.
I think Mr. Brezzi might have had a question.
I'm sure if I ask it, Ms. James is going to tell me wait for Mr. Ray to come up for traffic, so I'll hold it for him.
All right, anyone else for Mr. Halpern? I think we should open public at this.
Yeah,
All right, we're going to open this to cross-examination by the public at this time.
I'd like to make a motion to open the cross-examination portion of this application for this professional only. Sullivan.
Second, DiMarzo.
All in favor?
Aye.
So anyone wishing to ask Mr. Halpern questions regarding his testimony at this time, please come forward.
Seeing no one come forward, I move to close the public cross-examination of this witness and this witness only on this application. Sullivan.
Second, DiMarzo.
All right, so we'll withhold general comments then until the end of all testimony. Thank you, Mr. Halpern. Don't go far.
Okay, at this time, I'll call up our architect, please.
above grade.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Please state your name and spell your last for the record.
Naftali Gott, G-U-T, principal of Gott and Van Architecture, Lakewood-based firm. I have testified before this board, and these drawings were prepared under my supervision.
We accept your credentials. Thank you.
Thank you.
So if you could, Mr. Gutt, just walk us through the floor plan and layout. And again, just for the record, could you confirm that the applicant, the proposed building is going to meet the maximum height requirement of 35 feet?
Yes, me and Mr. Halper will work that out. We won't be over 35 feet. And just to mention, that's 35 feet plus a parapet, which you're going to be using to screening the mechanicals on the roof.
Just one question when it comes down to the height, right? So under the IBC, childcare centers are categorized into different use groups. One use group, I think it's like 1-4, has a 20-foot height restriction. Do you know what use group this is going to be categorized in?
Use group of.
Yeah, and childcare centers are categorized into use groups. And I believe 1-4 has a 20% height restriction when it comes down to childcare centers. So my question for you, the architect, is just what use group are we categorized in for IBC purposes?
It is I-4, I believe, with the sprinkler system. It is allowed to be 35 feet. Again, it's 2 stories.
All right, so the,
Two stories is.
It's the
is max
grade.
height.
I think it's the grade that's the issue, because this is what we used to term an English basement. It's not a totally underground basement. So we're talking about height from grade, correct?
it's height above grade. So it's 20 feet in height above grade. For a childcare center, it's limited to 20 feet. I think it's IBC statute 308.5. So the reason why I delved into that was simply due to the fact that, now that the conditions are removed, I just wanted to see what it would default to. And I just need some testimony as to how that wouldn't apply to you, or if it does, in what way, as to the use group.
Again, it's the 2 stories, which we're going to be compliant with, because the basement is considered a basement, being that it's not 6 feet above grade. So we will be compliant with the 2 stories. I'm not familiar with the 20-foot max. I mean, is that something that you?
Well, it's IBC statute 308.5. So I just want to be clear on the use group it's associated with, in case, because we're defaulting to different state statutes and use groups and everything like that. So I just wanted to clarify that issue.
Okay, so that will be clarified. But as far as my understanding is, 2 stories is the max, and the 35 feet would be, the zoning would be 35 feet, not the building. So long as it's sprinkled, then it would be allowed to be over 20 feet, just not more than 2 stories. But we'll get back and make sure that's true.
If you just speak into the mic. Yeah.
Yeah, we need, this is being recorded and heard by the public, so you really need to speak up, please.
Will do.
Thank you. So you're testifying that you will stipulate that you will abide by all state standards.
Absolutely.
Right, and if the IBC use group comes back and indicates that this
There's a
child care
20-foot.
center can only be 20 feet, you'd have to come back before the board pursuant to the IBC. Right.
Yes, understood.
Right, okay.
Thank you.
Anthony, can we bring up the architecturals? Next page, please. Thank you. Okay, so this project consists of a new construction, 2-story days care with a basement. The total gross floor area is 32,955 square feet. The building entrance is over here, and this leads you to either the basement or the upstairs through these stairs. The basement is, the entire basement is servicing kids under 2.5 feet, under 2.5 years old. And the plan includes 9 classrooms, a playroom, teacher's room, a lunchroom, a reception area, office spaces, staff bathrooms, being that they're all for young children. There's no bathrooms needed for the children. We have utility and storage space and a supply room. We have 2 exterior ramps, as discussed earlier, and this leads from the basement straight up to the front of the building. We have, besides that, we have the main stairs and 2 other stairs leading upstairs. All the classrooms are served with windows. In the back, where the grading is higher, we have window wells. Anthony, can we go to the next sheet? The first floor is serving children of all ages, and the plan includes six classrooms, each with their own bathroom. We have a teacher's room, a lunchroom, playroom, reception area, and office space. And we have utility and storage space and a supply room. On this floor, we have exterior ramp, 1 exterior ramp leading outside. This is the second means of egress, and an elevator. Can we go to the next sheet? The second floor serves children over 2.5 years old. Plan includes 8 classrooms, each with their own bathroom. Again, a playroom, a lunchroom, staff bathrooms, and a storage space. There are, again, 2 interior staircases and an elevator. Just to run through the size of the classroom. So for the basement, we had for younger children, those classrooms are servicing 12 to 18 children per classroom. The first floor was from 18 to 20 per classroom, various sizes. The second floor are larger classrooms, and those are serving 20 to 22 kids per classroom. Again, the ratio is always going to be 35 square feet per child. And being that these are larger, they have accommodating more kids. I believe it was mentioned already, the ratio, the staff ratio, but again, it's baby till 18 months is 1 staff member per 4 children. 18 months till 2.5 years old is 1 staff member per 6 children. From 2.5-year-old till 3-year-old is 1 staff member per 10 children. 4-year-old, 1 staff member for 12, and 5-year-old is 1 for 15.
Right, and just to be clear, just so the record is clear, the applicant's going to be complying with 3A:52-5.3, which is that children under 2.5 years old can only be in the first floor.
Well, yeah.
So-
Well, it's first and I don't have the actual language here, but what the requirement is that it needs to be on a level of exit discharge, and being that we have the 2 ramps exiting from the basement straight to the grade,
Mhm.
that would comply with exit of.
I think the level of discharge would be the first floor, though, correct? I think
Well, it's
within that statute, there's exemption language. You have to seek approval from the state if you're doing anything other than the first floor.
I mean, the first floor is no more than the basement, because the grade is somewhere metal, so.
So we'll make it clear that
I'll
you
make
will
it clear.
comply
Absolutely.
with the state standards again, and that should cover us all happily.
Absolutely.
I'm always concerned, and I've mentioned this, I'm sure Ms. Jennings will recall, about medical facilities. Of course, I see there is no medical staff, there is no nurse. However, having been an educator for 30 years, I know children, and they get sick, and they get injured, and they have medical issues, maybe need an EpiPen, that needs refrigeration. So there should be a designated medical area on each floor somewhere, either the teacher's room, which is on 2 floors, someplace on each floor should be designated as medical equipment.
That sounds good.
Thank you.
As mentioned earlier, the outside play area would not suffice for all the required open space. So hence, each floor is equipped with a playroom. On the basement, the playroom could accommodate 20 children. On the first floor, it could accommodate 18 children. On the second floor, it could accommodate 25 children. So that combined with the outside area should suffice for staggered play areas for all the children. Anthony, can we bring up I think it's Exhibit A1, that would be the color rendering. So the exterior is a playful exterior that would go well for daycare. And the material is primarily light stucco with a wood siding that we see in the inside of that canopy. We have colors around the windows in some areas with trim. And that canopy around the building entrance continues as a design feature at the front of the building and actually will be wrapping on the side of the building. As Mr. Happel mentioned earlier, the building signage at the entrance will comply with ordinance. It will be less than 80 square feet.
That canopy area will be over the ramp area
It'll be over
on the
right-
side of the building?
On the right side, yes. I know it's not showing clearly on the rendering.
Will
but
there be canopy on the left?
No.
Will there be some kind of overhang or some kind of structure to protect those sidewalks from ice and snow and rain?
Not in the design, but it can be.
I think maybe you need some type of overhang
Is that for the
protection
ramps, you worried about? Okay.
over the stairways.
Okay.
Thank you.
All the mechanicals will be on the roof and it should be screened by a 4-foot parapet. The mechanicals will be inset to the center of the roof and should not be visible from the street. And the roof will be solar ready, though the applicant is not proposing to put them now. Just a couple of general comments. The full building will be sprinkled. There will be a fire alarm throughout the full building. There is an elevator that connects all 3 floors and plus the primarily entrance area, which is in between the basement and the first floor. We have a minimum of 2 means of egress at each level, and we have more from the basement. Again, all classroom servicing children under 2.5 years old have 2 exits from the actual classroom. As Mr. Happel mentioned, food will be delivered, no cooking on site, and food will be stored in the storage room and served in the lunchrooms. Again, the building will comply with the 35-foot height. And that, I believe, I did address all of Mr. Peters' comments, and that concludes my testimony.
Could you repeat that last condition, please? What you just said. Just repeat what you said.
About the building height?
Yes.
Yeah, we will comply with the 35-foot building height. We will make sure, work out with Mr. Halpert, that the average grade to the top of the roof will not be more than 35 feet, plus the 4-foot parapet.
So just to be clear, so a class 4 structure under the IBC, if this is a childcare center, can't be any more than 20 feet and 1 story. So if, again, I'm
If
just,
that's the case, we'll
right, so
have to
if you
come
get,
back.
if you get the building and you submit for building, and that's the use group that you're looking at, then you guys will be coming back.
Understood.
Okay.
Please continue. Thank you.
That concluded his direct testimony.
All right. Mr. Clay or Mr. Peters, anything for this witness? Anyone from the board?
Just one comment, I apologize.
Oh, thank you.
Mr. Good, thank you for your testimony. The site civil said that there'll be compliant signs for the site. Can you indicate that the building will have compliant signage?
Yeah, we would comply with the 80-foot max square foot for the signage.
Thank you.
I just have a couple questions. Mr. Scott, the elevator, will that be open to the public, or will that be key carded, or a key system?
Yeah, key system probably. Well, it's not meant for the children. It's
Only
meant
for staff,
Only for staff.
Okay.
and
Okay.
emergencies.
not for parents.
Correct.
And also, I'd like to make the suggestion, possibly, since you won't have nurse on premises, that you have a first aid kit in all the classrooms.
Absolutely.
Thank you.
I have,
Mr. Rogers?
I have a question on the lunchroom. Would there be any cooking equipment in the room?
No. All the food is brought on site and just served in the lunchroom.
Everything's going to be delivered either refrigerated or
Well,
heated?
usually it's like a caterer that pulls up and just brings the food ready and it's served just like that.
No, but it's prepared.
Correct.
Ready to
Pre-prepared.
eat. Right.
Heated everything. It's just ready to go.
Okay, so now it's on the rear right-hand side of the site, the loading area.
Mr. Rogers, would you pull your microphone a little closer to you, please? Thank you.
It is, your loading area is on the rear right-hand side of the site, am I correct?
Correct.
Okay. Now, what door would the product be going into on your
Sorry?
plan? What door will that food product be going into?
Well, likely be going into that door adjacent on the side.
Okay.
Maybe we can pull the site plan up so everyone knows what we're talking about.
Likely be going over there, and maybe for the basement, they'll bring it down, either these stairs or these ramps.
That's
that go
on
straight to
grade?
the basement.
That door's on grade?
No, that door is the stairs there, and that door is a couple of stairs up to the first floor.
Okay, so,
This ramp is at grade, and that could be wheeled straight down.
okay, so how far is it from the loading zone to that stairway?
I'm sorry?
How far is it from the loading zone to the stairway?
Has to ask the site engineer that. Hold on a second.
It would be approximately 50 feet.
Okay. So from a food safety perspective, you're going to have 400 meals, plus or minus, okay, that are going to be transported in the open air without protection from any elements into the building and then brought into the lunchroom on the first floor. You see that as an issue?
Well, it always comes packaged really nice. Caterer prepares it, puts it in some kind of packaging and sends it in boxes.
Right, ready to eat packaging, but you're now transporting it in bulk, right?
Correct.
Okay, so is it going to be, if they unload the truck and leave it on the loading area, how long is it going to take?
Well, they're
before
going to
that
bring it directly in. It's coming during active hours of, it's not coming in the morning. It's coming during, like at lunchtime, it gets delivered, like at lunchtime.
That's what I'm asking. So lunchtime,
And they
give
will
Yeah, but-
bring it right in.
And it's not like your lunch is open. It's in a warming container, so it's
that's what I'm asking.
covered by the elements. So it'll be brought in with these warming containers, and then once you get to the room, you pull out the lunches from the warming container. So they're never exposed to the environment, if that's what you're concerned about.
That's what I'm concerned about. Is if they're not in warming or cooling cabinets, okay? That's why I asked. But they still have to need to be brought in quickly. They can't be sitting out in the sun. They can't be sitting out in the.
Yeah, and that won't
No,
happen. They
I
do this all the
agree.
time. They bring it right into the building.
Mr. Brezzi?
Yes, I hope it's the right person. Security, cameras, inside and out.
Correct. There will be cameras, and there's no security guard, but the door stays locked at all times.
They locked. Now,
Stays locked and
will
gets
you
buzzed
give
in.
access to the police department to access that in emergency, or can you cross with the police department so they can have access to the cameras and so forth?
Okay.
And that's inside and outside, correct?
Well, there'll be cameras inside and outside. That could be connected to the police department.
Thank you.
And who is monitoring these cameras?
There's someone whoever's in the office will be monitoring them.
All right, so you have office personnel monitoring.
Cameras. And
We live in a dangerous world.
Understood.
Security is crucial. And
Absolutely.
having been involved in school security for decades, we want to make certain that your
we're
staff
monitored at
and
all
your
times.
school is safe and monitored at all times.
Yeah, absolutely.
I have a question, thank you. So if there is a fire, I'm still having a hard time understanding the children that are going to be in the basement and how they get out. So there's a fire, and now no elevators will be working. Where are my kids going?
Never
Can we
use the
bring up-
elevator.
Can we bring up the architecturals again? Thank you, Anthony. That'll be the second page, I think. There we go. So again, we have the classrooms
great.
around the perimeter, right here and right here. These are ramps that lead directly to the front of the building.
So there's no stairs there for them, they just walk
there's-
out?
Well, they walk out to this area. At this area, they're out in the open element. They're out of the building footprint. This is exterior already. There, they make their way up. Ramps, stairs. Besides that, we have a fire enclosure stair here and here. So essentially, there's 4 means of egress, and once you're in this area, you're in a rated
Worst comes to worst.
area until you actually exit the building. And the same applies for here.
So are they going up the steps?
Well, these are going up the steps. This leads to the first floor. This leads to the first floor. This is only a half a stair, and it leads to that front entrance, which is in between the basement and the first floor. And these 2 exits, once you get here, you're not at grade yet, but you're right over here. You're at grade, so you're outside of the building, and you make your way up the ramp. And we have that on both sides of the building.
Okay, and there is a classroom number 9 in the basement that's 0 to 12 months. Is that, and that says it's going to be 12 children. Is that the most 0 to 12 that you're going to have?
Well, again, the ratio is 35 times 12 is 420, so the 12 would be the max allowed for that classroom.
But will you have, I don't see any other classroom within any of your plans that say 0 to 12. Is that the only?
Oh, understood, yeah. But there's not that many of those children that age sending, so there's just one class dedicated for that.
Okay, thank you.
Any other questions? We'll open this to the public for Mr. Gott, please.
I'd like to make a motion to open to the public cross-examination of this witness on this application only. Sullivan?
Second, DeMarzo.
All in favor?
Aye.
Aye.
Please come forward.
Thanks, Anthony. Carlos Martins.
Oh, hang on, Carlos. Yeah, please raise your right hand. Do you
Right
swear-
hand.
The other one I do it, and they say no.
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes,
All right, please state your name and spell your last for the record.
Carlos Martins, Martins.
And you're here in your individual capacity, correct?
Yes. that's
Okay,
right.
not as a representative of the zoning board?
No. Okay. Nothing to do with the zoning board. Anthony, could you bring up that, the pretty one where you can see the front? Yeah, right there. Okay. So as a non-engineer, right, I look at this and I see 3 floors, right? One, the basement, one, two. So my question is, what's the definition of a basement versus a floor? Like,
This-
what's that key?
this
It's
is
not
a-
that it's underneath, but what's that key aspect?
This is what we used to call an English basement. That means that 6 feet of it is below grade, and that's the standard. So it's really not, it's a half of it is in the basement, and that's because for safety and light, ambient light, windows, so there's
If we could have
there's
the applicant
standards.
answer the question, that'd be,
Well, you said it right. It's less than 6 feet. It's considered a basement. So even though it's partially above grade,
Right.
so long as there's no more than 6 feet above average grade, that's considered
Oh.
building code as a basement, and that's considered a story.
Right, as long, it sounds like 6 feet, but as long as there's a section that's below grade, it's a
Well,
basement.
yeah, it's the average grade. So you have
Average
to
grade.
calculate the average grade around the whole building.
Oh.
And if you're 6 feet below that, then it's considered a basement. If you're
And
over
it's the
6
grade
feet, it's
around the
considered a
whole-
floor. Correct.
Okay, that clarifies. Thank you. That's very helpful. Just another thing that based on at least this question. So in the basement, there are going to be infants, for example?
Correct.
Okay, so in the case of a fire, infants can't walk out and run out themselves to climb those stairs, right? So let's say there's 20 infants down there. Will there be 20 people that'll carry them out?
Well, there's
During
two
a
staff
fire?
members in each classroom,
Right.
plus additional staff members throughout the building.
Yeah.
And those regulations are partial to certain that during emergency, everyone gets out safely.
Right, and that's per regulation, right?
Per regulation.
Yeah, 'cause, yeah. So if I'm down there and I can only carry two, which two do I pick? I mean, I just, you see those difficult situations, but if that's regulation, that's fine. Okay, thank you, I appreciate it.
Thank you.
That was it.
Thank you. Anyone else?
Seeing no one else come forward, I move to close the cross-examination of this witness on this application. Sullivan?
Second, DeMarzo.
All in favor?
Aye.
Mr. Chair,
Thank you.
I have a question for him.
Mr. Brezzi has a question.
I just want to take off where Mr. Marzo left off. And you indicated that from the basement, staircase 2 is a way out for the basement. And the only way I see staircase 2 being a way out isn't quite an accurate description, because you got to go up to the first floor and then to the sides. There's no direct outside. I don't think you should be counting that as an exit from the basement.
That is true.
I know it's true. I'm looking at it.
Right. Again, it is a way out of the basement, and once you get to that second floor, you have less than the allowed.
Once
travel
again,
distance
coming out
till
of
you
the
get-
basement, they don't have another access outside. It's only the 3, not the 4 you mentioned.
True.
Thank you.
And these are all compliant with state standards.
Absolutely. Again, it's building plus a child.
All right, thank you very much.
Thank you.
Okay, at this time, I'm going to call up the traffic engineer, John Ray.
we need to close out the cross-examination part.
Oh, sorry. Motion to close the cross-examination.
I'd like to make a motion to close the cross-examination of this witness, Sullivan.
Second, DeMarzo.
All in favor?
Aye.
I think we did. All right,
Senior moment.
senior moment. Only I am allowed up here. Oh, maybe maybe 2 of us could have a senior moment.
I'm over 50, I might be too as well.
All right, okay. Mr. Ray,
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Since you're such a stranger here, why don't you give us your background?
John Ray, REA, professional engineer with McDonough and Ray Associates, specializing in traffic engineering.
All right.
And I've
Accept your
testified
credentials,
before this
Mr.
board
Ray.
before. Thank you.
If you could, Mr. Ray, just for the record, your office has prepared a traffic impact study, last revised July 23rd, 2026, correct?
Yes.
And if you could you just describe your traffic impact study, what factors you considered and your conclusions, please?
Okay. The traffic impact study, as Donna indicated, was last revised July 23rd, 2026. what we did in order to develop design year 2036 traffic volumes, I know the board remembers that the Ocean County Planning Board requires us to look at a 10-year horizon when we do our traffic studies. So we have to project traffic volumes to a design year of 2036. In order to do that for this project, we looked at several other projects that we had worked on in the area. And specifically, there were 4 other projects that are either approved or under construction that are in the vicinity of the site along South New Prospect Road. We added the traffic from all 4 of those projects. And in addition to that, we did add the NJDOT's background traffic growth rate for the area. So if anything, we probably double counted the, looking forward to the 2036 design year by using 4 specific projects that we were familiar with and including the DOT's background traffic growth rate on top of that. And when we looked at the size of the project and we looked at the ITE data for a daycare center with 400 children, it became apparent to us that we needed to make some improvements along South New Prospect Road. Mr. Halpert discussed those improvements. We are going to have to do some widening on the opposite side of South New Prospect Road so that we can install a 2-way left turn lane along the property frontage. That has been discussed with the Ocean County Engineering Department. This is what the county wants. And since South New Prospect Road is under the county's jurisdiction, that's what the county's going to get. They're going to get their 2-way left turn lane. And quite frankly, we need that in order to make the access and the egress to and from the property work properly. One of the other things we did, and one of the other reasons why the traffic study was revised, was we did add a separate left and right turn lane at the exit driveway. I discussed that with Mr. Halpert. We need that for safe and efficient egress from the site. So we do have separate left and right turn lanes exiting the site out onto South New Prospect Road. With respect to, there was some discussion about losing a couple of parking spaces which were close to the entrance driveway and exit driveway. We can lose those 2 parking spaces. We have a little bit extra parking spaces, as has been testified to. And I want to go over the parking numbers in a little bit more detail so everybody understands why we're providing the additional parking spaces over and above the 66 spaces that are required by code. A couple of things. The 53 staff members that are going to be at the site, that doesn't necessarily translate into 53 cars being parked there. There'll be some absenteeism. There'll be some carpooling. My expectation is there will probably be no more than 45 cars associated with the 53 staff members any one particular day. And that would leave us physically approximately 40 parking spaces left for the parent drop-off and pickup procedures. And there's a reason why we came up with that number. In our experience doing daycare centers, and we've done quite a few of them over the years, we have typically found that we need, for every 100 kids that are in the daycare center, we need 10 parking spaces for drop-off and pickup. So if we have 400 children, we're looking at 40 spaces that are necessary for the parents for drop-off and pickup. Now, that's probably an overestimation of what we really need because at least it's my understanding that approximately 30 of the staff members are going to be parents that are working here that are also going to have several children at the daycare center. For argument's sake, just if you wanted to take a look at what we expect, if 30 of the staff members each have 2 kids in the daycare center, that reduces the number of kids that will be dropped off and picked up by the other parents. So that'll take 60 kids out of the 400. You're looking at probably 340 in terms of what the actual drop-off and pickup procedures will need to take care of from the parents that just are bringing kids to the daycare center, not including the people that work there that already have kids at the daycare center.
Mr. Wright, does the staff have designated parking places?
We can designate parking spaces for staff. My recommendation would be, putting the staff to the rear. These are EV spaces. The staff should be, we should probably keep the spaces adjacent to the building and the ones closest to the building for parent drop-off and pickup,
Closest to the front.
closest to the front, and put the staff members to the rear and toward the back of the 2 aisles on either side of the building.
Could we stipulate that,
We
please?
can stipulate that, yes. That's always a good idea.
Can I just ask a question? It's the plan to rotate the teachers every 5 years because they may have 2 or 3 children that qualify now,
Yes,
but in 5 years, they may not.
that's correct.
So now you're going to be back to the 400. So we probably. How
But
many
but
kids-
there will be new people working there. Every year, things are going to change, Mr. Rogers. And the state is going to look at this every year in terms of actually, and that's the other thing that I didn't mention. You know, we're looking, in doing the traffic study, I'm looking at a maximum of 400 students. Realistically, when the state comes in and looks and gives us, you know, what we're going to be allowed to have, it's going to be somewhat less than 400. It always turns out to be less than what you're originally expecting. So, but the state's going to look at this every year and make adjustments.
Where does that stand on our approval process? Because we're going to be asked today to approve based on 400.
Right.
Okay. So now, to me, you show 169 trips in the morning and 147 in the afternoon. Do I
Right.
have that right? Now, if I look at it and say, okay, there's 400 children and they're going to come within a 45-minute drop-off time. Go from 8:30 to 9:15. Okay? So if I put 2 children in each car, that's at least 200 cars.
It might be more than 2 children per car.
It is.
Based on our experience.
Yeah, thank you.
It's more than 2.
Okay.
Okay, I won't take it any further than that.
Okay, so I don't see how the trip generation could be at the numbers we talked about.
Okay, well, let's back up and take a look at those numbers because I think that they're pretty accurate. Assume for the moment that, you know, 30 of the staff members will have 2 kids. That leaves 340. That will
But
be.
why are you going to give them 2 kids and not the others?
They have 1 kid, all right? So you got,
Thank
you got 370.
Right.
And if you have 2.5 kids per car, you do the math, it comes out to just about the numbers that we expect. In the AM, 167 cars coming in, 2.5 kids per car, or even 2 kids per car. Even if you look at 2, Mr. Rogers, you're up to the, you know, roughly about what the capacity of the building's going to be. Roughly a little bit more than 2
Now
kids
I'm
per
going to go
car.
back to you. That might be good if they have mothers with 2 children or 1 child in the car. They don't. What happened if
They
5
will.
years that they never do again?
I
People want to work to 25 years, get a
Well-
retirement, 401k.
Well, then I would suggest if you're uncomfortable with the amount of parking that we're providing, the town should probably change their ordinance because we are providing substantially more traffic than your ordinance requires, parking spaces, excuse me, because we believe we know what we need. And so we're telling you, we need 30 more parking spaces than your ordinance requires.
But your parking in your stand-up line for navigating the site is 2 different things.
Correct.
Okay, according to the ordinance, we may need 66 parking spaces, but you're going to have another 100 cars that are going to be on site, okay? And they're going to have no place to park, and they're going to be standing trying to drop off the kids. That means the cars that are in the parking space, they're going to be able to pull out. It doesn't sound like it works to me. I'm not saying it does. I'm
Okay.
sure you guys are smarter than me, but I'm just asking how.
No, you're asking good questions, and I ask the same questions of the applicant because I want to come up here and make sure that when I testify in front of this board, that I'm giving you guys the, you know, the information that I think you need to get in terms of, is this going to work or not? And that's why we're asking for the extra parking spaces. So I agree with you 100%. It's a concern that needs to be taken care of. I think we've done that by providing the additional parking spaces. And also, as Mr. Halpert indicated, staggering the drop-off and pickup times in 15-minute intervals. It's my understanding that the applicant runs another daycare center in Lakewood, knows how to run the operation. This is how that operation is run in Lakewood, and that's how it's going to be run here in Jackson. There are going to be staggered drop-off and pickup times, and we're providing the additional parking spaces.
in all due respect, without knowing the condition of the Lakewood site, this site's a little tight and it's on an incline. It's above the roadway. Now, you're talking about every 15 minutes, if there's 200 cars.
Well, it
you're
won't be 200 cars every 15 minutes. It'll be
No, I'm not saying
40 or
that
50 cars.
75 might be better, 70, 75. But I'll go with you.
Yeah, the
Okay.
numbers
Now,
come out to more
you
like
got
40 or 50.
mothers and fathers getting out, dropping the kids off at the door, making sure they get in, and the next group's coming. How do they get out? And how do they get in? What I'm concerned about is the amount of traffic, not necessarily how they park.
Okay. Well, typically, based on our experience looking at some of these daycare centers that are in the area, the staff members do during the drop-off and pickup times, the staff members are out in the parking lot helping control traffic. That's a part of the situation too that we haven't discussed, but that happens.
Respectfully, I think we decided we didn't want that.
Yeah, we don't want parents, and we don't want staff picking up children out of the car, but to be out supervising, drop off
That's what I'm
and
talking
pick
about,
up.
Dr. Campbell.
Yes.
Yeah, we just did a daycare center in Howell at Kent Road and Church Road. You may be familiar with it.
How many students there? How many children there?
It was less than this, but they just got an approval to expand to, I forget the number, pretty close to 300 students. They just got an expansion.
Because I know the Cocoon in Lakewood, there's 150 students,
Okay.
children.
Right.
So this is like more than double.
That's why we're providing all the additional parking spaces. I agree.
May I ask you another question?
Sure.
On your table 1 trip generation daycare
Right.
center, you have 270 children. Is that a typo?
That's a typo, because if you look back up in the earlier part, it's 400. We just didn't change the two. Originally, it was 270. That's one of the other reasons why we revised the traffic study. We did the trip generation numbers are based on 400. But
Do you know why they increased it from 270 to 400?
I don't know why that's the number that was given to me. I think we decided, originally, I think the 270 was only going to use 2 floors of the building. And as the architect and Mr. Halpert testified to, there's going to be 3 floors now. I think that's why the capacity was increased to 400.
You do recognize the concern that 400 students, once approved, can't be unimproved. So if it doesn't work, it doesn't work.
Again, Mr. Rogers, we're asking for a maximum of 400. When the state comes in and gives the total approval for what, we can have, it's going to depend on the ages of the kids as far as what the capacity of the building can be. It's not going to be 400. I've never seen the state come in and approve a daycare center for more children than we've asked for. It's never happened.
And by the way, the state, I believe, comes in twice a year to inspect.
I knew it was at least once a year, but
I
twice.
believe
Okay.
it's twice a year
Okay.
to inspect.
Okay. I did want to mention something else about the marginal road, because that was something the police brought up as well. The marginal road has 3 points of access to South New Prospect Road. There's the one that's adjacent to our driveway, our entrance driveway. There's another entrance via New Mexico Street in the middle of the marginal road. And then there's another entrance to the far, I guess it would be east end of Marginal Road. There's another. So there are 3 connections to South New Prospect from the marginal road. And the one connection that's close to where our entrance driveway is, it serves a relatively limited number of homes. So I think, given those factors, and I know the police were concerned about it, there's not a lot of traffic that's going into and out of that particular location. So in my estimation, it's not going to be something that's unsafe.
Mr. Ray, it was not the traffic emanating from the Brookwood there that concerns us. It's the lining up
Right.
of parents' cars for accessing that daycare center. That's the concern.
Correct, Dr. Campbell. And I listened to the testimony, and I think there was some discussion about having the elected officials pass a no stopping or standing regulation. I would only suggest that if the elected officials do that it be limited to the hours during the week when the daycare, 8 to 10 in the morning, or whatever the numbers may be, whatever the hours may be. You don't want to have the residents that live along the
No, it's
marginal road
not,
not
it's
being
not,
able to park
yeah,
there on
it's not
weekends.
no parking. We would not ask for no parking. We're asking for no stopping or standing.
Right.
That's a different
It is a different regulation.
regulation. So that it's only during drop-off and
Right.
pickup time will be the issue.
Correct. I'm just saying, rather than inconvenience the neighbors by having it
Never.
be a 24-hour regulation, just do it during the peak hour, the drop-off and pickup hours during the week.
Mr. Brezzi wrote that down,
Okay.
Question two.
and he has a question.
How close is the exit from Romeo's Plaza to their entrance?
I have to look at an aerial. It's quite some distance.
Is it?
It's a ways.
Yeah, it's quite some distance. Romeo's is up at the corner.
Corner, right, but he has
of,
the entrance on
Aldrich
that
Road
one
and
side of
Banks
South
Mills.
Prospect, on the other end of his property
Right.
there.
Give me a second. I could take a look at an aerial.
It's a considerable way, but the really good part is the county improvements. Going to make
Yeah,
a huge difference, because at that spot, it narrows. When you go down that road, when you're coming from Romeo's, it's more lanes as it,
And it narrows.
and it
funnels down.
narrows perceptibly. So that will improve things a great deal at that intersection.
The county doesn't let us get away with anything. They want
Nor
the
do
three-
we.
They want the 3-lane cross-section, and you guys do the same. So I'm here testifying because I talk to my client, I tell them what they need to do. Sometimes I get pushback. If I get pushback, I stay home. I don't come here. They didn't push back. They understood that this is what they needed to do, and we worked it out with the county. There's going to have to be widening on the opposite side of South New Prospect to provide the center turn lane, and that's what we're going to do. The county's going to require it.
Can I ask a question on that, please?
Yes, sir.
The widening, I already heard that the applicant is going to take care of the restriping of the road.
Yes.
Does that apply to the widening as well? The applicant will do that, not
Yes.
the county?
It's shown on Mr. Halpert's plan. If
Okay.
you look at his plan, there's a shaded area on the opposite side, and it says, but new pavement and new edge of pavement. So there will be a widening that the applicant will be required to do as part of the county approval.
Okay, thank you.
Just have one more.
Yes.
The entrance, would it be of any benefit to double the 2-lane entrance so that you could get the cars off New Prospect faster?
Nah, but the exit is good, Mr. Rogers, for 2 lane, but the entrance, you don't want cars pulling in 2 abreast. That'd be like, you want them to come in one at a time so that they can find an open parking space, bringing cars in 2 at a
I
time.
was
I
only
think
thinking because you got a left-hand turn and a right.
Because if you look at the plan, there's only one receiving lane once you get into the site.
Yeah.
There's only one receiving lane for entering traffic. You don't want to bring 2 cars in at once. Yeah. And you can see from the aerial how far we are from Romeo's Plaza. We're at least 500-600 feet, maybe a little bit more from that driveway.
Mr. Sullivan?
Yes, do you have a time frame as to when the county will be doing the turn lane in there?
We're going to have that in before we get the county, before we get a CO. That's going to have to be done.
Okay, so that's, all right, I wanted to make sure.
Yeah.
And Mr. Brezzi?
Yeah, and Mr. Ray, I know you a lot of years, I've all the respect in the world for you. But I'm having a hard time with Mr. Rogers with the parking. I understand it sounds like a lot of parking and extra parking, and parking standards don't go by how many people, it goes by the square footage.
Right.
But now with 400, and you got X amount of cars for employees, and then every 15 minutes, you got another couple hundred cars coming in to pull in and park and take their children out. You still don't have enough spaces like that. How are they going to pull in, get their kid out, take them to the front door, while the other cars are pulling in? You're talking 45 minutes and 15-minute increments for over 200 cars.
Well, it's going to be, let's go back and look at the trip generation numbers. The 167 that entered during the morning peak hour, some number of those cars are going to be from the staff.
And
Maybe-
most likely, they will enter a good half hour
Yes,
prior
right.
to the building opening.
So of that 167, maybe 45 of those vehicles will enter before 8:30, before the other parents start dropping kids off. So if you back up and do the math, you're looking at roughly 120 to 130 cars in 3 15-minute increments. You're looking at roughly 40 cars every 15 minutes, more or less, 40, 45 cars every 15 minutes, which is manageable. It's not 200
like
cars.
60,
It's
65.
40 to 45 cars every 15 minutes.
And we know from experience that these cars will often have not 2 children in them, but 4 or 5 children in them as mothers carpool.
That's been our experience.
That's been
Right.
our experience as well.
It's at least 2. That's why I said maybe 2.5, 3, children per car, roughly. So-
And the staff, the same issue happens at the end of the day. The staff members who are there will be bringing their children out after the main
That is correct.
group parents have left. So that also
That's-
changes your
That's how it operates. That's correct.
ratio, because those staff members will bring their the whole place will be empty of parents, and then the staff members will leave. That will like another 40 cars leaving.
So we can make that a requirement then, that the staff has to leave after all the children are gone?
Sure.
Believe me, no principal is going to allow the staff to leave before the parents are all out of the building, but we can stipulate that. Why not?
Absolutely.
And what happens when those
Madam
teachers
Chair,
don't have any more children?
Yes.
I apologize. I was going to wait until everyone was done to make a comment and ask a question or make a statement. But Mr. Marza sort of hit on the making it part of the application or making it part of the resolution. All of the board members here this evening asked a question about safety as it relates to traffic, parking. So to that end, as we've done with other applications where we have unique drop-off and pickup times, whether it's a daycare facility, a new school, I think it's probably prudent to have some sort of, whether it's a condition in the resolution, a deed restriction that says this approval is conditioned upon them utilizing this schedule, because we're relying on Mr. Ray's expertise that he gleaned from his applicant that those 3 15-minute periods are going to accomplish this. And quite frankly, as a professional, we can weigh Mr. Ray's testimony, give it credence, make a decision from that. However, at some point in time, this thing's going to get sold. 5 years from now, 15 years from now, 30 years from now. But 30 years from now, the operator that's here probably won't be here in 30 years. That's when the questions start. We're going to have a capacity for 400 students, or we're going to have 3 floors of a 33,000 square foot building that at 1 per 500 require a certain amount of park. And the use of the building is going to change. So I would suggest, or I would ask Ms. Jennings, as the attorney for the applicant, is a deed restriction as it relates to the pickup and drop-off times over the top?
Yes, it's over the top. It would be a restriction in the resolution that it'd be okay with, because if there was any change in use, for example, or change in the user, that you're gonna have to get a zoning permit, and the zoning officer would flag it and say, you gotta show that you're gonna be following these requirements. And if you're not, and you're gonna be a different use, you'd have to come back to this board.
And the reason I asked to what level we set enforcement is because on this site, there's no safe overflow. The safe overflow for this site's a county road. We didn't ask what the speed limit was, but it's a county road. So there is no safe overflow. And so our concern is that we need to make sure the 2 attorneys come up with language that's specific to this application and enforceable out in the field. Thank you.
Thank you. Very, very well put.
The applicant will agree to such a condition?
As a condition, yes.
Yep.
I still question the detail of the plan to create a restriction. I can't understand how we could say in perpetuity there's going to be 40 staff members with the kids that are going to be coming early and leaving late.
You know, Mr. Rogers, I spent almost 40 years uh, administering schools. And I can tell you that much of that time I spent hiring staff. They change annually so that when someone's children are getting older, they move on to a different position where they are available to those older children. And parents who have younger children will come in and work in the school where their age children attend. So it's an interesting circular motion. When I taught first grade, I had younger children, and my children attended those schools. And when I taught high school and administered in high school, I had moved on to high school to work. So parents are like that. They adjust to schedules, and schools are like that. And I don't know about this school, but there are some places that give tuition breaks to staff so that the staff may find that they have a financial interest in working in a preschool when their children are in preschool. That's how the system works.
Well, I admire that, but as our planner said, there's no safe.
There are no
overflow.
guarantees. There are no guarantees, but there are standards, and there are experiences. Mr. Ray and people who run schools understand that these are
That's your opinion.
experiential. Thank you. Any other questions? Mr. Marza?
Mr. Ray, in Mr. Peters' review letter on page 9, he brings up that there are several waiver requests in connection with the entrance drives, the exit drives, and
Right.
no parking stalls. So did you took all of this into consideration when you were getting your study revised?
Yes, and the reason why we need waivers from those specific items is that, in my opinion, and I've testified on this before, those requirements, I believe, were typically put in for shopping centers that have a lot of in and out traffic, all day long traffic coming and going, not for a situation like this where you're going to have traffic arriving in the morning, departing in the afternoon. They're going to be repeat users. The parents are going to be the same people that drop off and pick up. I believe those requirements were put in to basically take into account something like a shopping center, very high turnover, like the Walmart out on Route 9 in Howell, or the ShopRite on County Line Road, where you have a lot of traffic coming in and out all day, different users, not the same people every day. That's what that requirement was put in for, in my opinion.
And the board's granted these variances,
Yeah,
design
board-
waivers,
yeah,
and a number of.
these waivers have been granted quite a few times before, when the situation warrants it.
Correct. Thank
Right,
you.
Right.
Anyone else on the board with questions? Thank you.
Thank you.
I do.
Then we're happy to hear them.
Mr. Ray, thank you for your testimony. We really didn't talk about levels of service. We sort of stopped with
Got
that
it.
to parking. So we didn't talk about levels of service at the site, nearby, any of that stuff, so.
Okay, let me go to the report. I believe we have a C during the 1 peak hour and a D during the other. Give me a level of service D, as in David, during the AM peak hour, and a C during the PM peak hour, because the morning peak hour volumes are actually a little bit higher. So a D during the morning and a C during the afternoon.
And both of those are acceptable levels of service.
Acceptable, and that's one of the reasons why we need the two-way left turn lane. Without the two-way left turn lane, we wouldn't be able to achieve those levels of service.
Thank you. Is there a need to review the levels of service at the traffic lights to the north and south of the subject site?
That is something that we haven't done as of this moment. My expectation, based on what the county has been asking us, is that the county will ask us to do that. That's my expectation, based on past experience with the county. They've been asking us to expand our traffic studies. We just got a review letter from the county on a project off of Hyson Road. And they asked us to expand it to include the signal that was adjacent to the site, and that's my expectation. They're going to ask us to do that.
Could we make that
You
requirement?
could do that, yeah.
Let's,
What's in it?
that Mr. Ray will check the traffic lights at the north and the
At
south
Bennett's
end.
Mills and Aldrich and.
At Bennett's
what's
Mills and
okay.
Aldrich and County Line, no, at Brewers Bridge and New Prospect.
Okay.
How should I articulate that?
Actually, Mr. Halpert just indicated to me that in this particular situation, the county did not require it.
But we're going to ask that you
Okay, but
do
you're
that.
going to require it.
We're going to require it.
Okay.
Yeah, so let's just go back to the phrasing of that.
Let's go back.
Yeah, we
How
gotta-
will we phrase that?
We're going to check the levels of service.
At the adjacent signalized intersections.
Both north and south.
Got it.
And again, the reason from this board's perspective is that there are really just two peak hours. There's the morning peak hour and the afternoon peak hour. Morning peak hour may coincide with the AM peak hour for the neighborhood. I doubt the afternoon peak hour is going to match up, but again, we don't know, and so I think we're entitled to ask for that information to make sure we have an understanding if there's a significant degrading of the level of service at the intersection, what's the county doing or requiring?
We all know that traffic is the bane of Jackson. So I
So we can
think,
ask lots of questions.
yes. So we
Okay.
have to depend upon the county and Mr. Ray and you to make sure that we are alleviating traffic as much as humanly possible. And maybe if that means staggering their timing or whatever the heck they do to make level of service as good as possible.
Mr. Ray, the left turn lane in, I didn't see I see the individual level of service was either the left turn in or the left turn out was in excess of, I think, 35 seconds, so it was individually a level of service E.
The D level of service is a weighted average.
Right.
The left turn is an E, the right turn is a B.
I'm wondering if we have any idea about the stacking that would be necessary on South New Prospect to make the left turn into the site. And similarly, if we're aware of any stacking for left turn lane on the way out. I guess we'll do them one at a time, I guess.
Okay, well, as far
South
as,
New Prospect into the site.
as far as the left turn in, we have the whole frontage of our site. There'll be a two-way left turn line along the whole frontage, and that's going to be in between the two driveways. We're looking at 150, 200 feet. That's going to be good for,
We're just crossing one lane of traffic there, right?
yes. So
So
we're going to be fine with respect to the stacking coming into the site. As far as the stacking exiting the site, it's all going to be contained on the site, and it really won't have an impact on South New Prospect. Whatever stacking is exiting the site, it's going to be contained on the site. And what will happen because of the signal up at Aldrich and Bennett's Mills, just to the north of us by Romeo's Plaza, there will be, some gaps that the signal will create that will permit that traffic to get out of the exit driveway a little bit easier
Well,
than
that's really
than the model actually anticipates.
that was the nexus of my comments, was that does there need to be a gap analysis from Aldridge Road heading south on South New Prospect to make sure the lefts can get out of the site?
If we had a level of service, usually when we get a level of service F for a particular movement, that's when we do the gap studies. We have an E, not an F. I don't think it's necessary, but certainly if we had an F, we would have to do it. I just had to do something up on Red Hill Road in Holmdel. We had a level of service F coming out of our driveway. We had to go out and do a gap analysis. And if anybody's familiar with where the Memorial Sloan Kettering Cancer Center is on Red Hill
Just
Road,
there.
that signal created gaps for us. And
Thank
even
goodness.
though the calculation was an F, we had plenty of gaps. So sometimes you have to do it.
And lastly, just so it's on the record for our application, we often get questions from the police department about traffic exiting the site, crossing double yellow lines that will now be part of a dedicated left turn lane. That is permitted, correct?
Yes, it is. Yes.
We had testimony on that on so many applications. Yes, that is permitted.
Right.
Thank you. That's all I have, Madam Chair.
Mr. Clay, any thoughts? You're good? Mr. Brezzi?
I'm just looking at what's in front of me, so it could be wrong, God knows. But on a map with the county,
To the microphone, Mr. Brezzi. Thank you.
the county plans are showing from your exit coming out, directly across from your left and right coming out,
Right.
shows an arrow going in the lane there.
Well, that's just, that's the way the two-way left turn lanes are striped, Mr. Bressy. They just have the arrow, just to show people that when you're approaching the left turn lane, you can make a left.
Yeah, well, that
You
one
don't, you
shows-
don't make it at that specific location.
Well, I can understand that,
Yeah.
but what I'm approving here shows it goes right into the people coming out.
We could revise that.
Thank
That's,
you.
know,
That would make
that's
me
not
very
an
happy.
issue.
And
And
you'll
the
do
county
that.
will probably make us, relocate the arrows on the pavement where they want them.
There are occasions when people follow the arrows,
And try to enter the exit driveway. I got you.
Yeah,
While I'm here, I have one other question.
as long as you're here.
This is more from Ms. Jennings. I know you haven't received an environmental letter from the Environmental Commission yet. Would you be stipulating that if you get a letter of concern, you come back in front of us?
Well, you come back here?
If you have a letter of concern, you come back. A letter of no concern, you don't have to come back. But if the
I
Environmental
don't know what a
Commission,
letter of concern is. What is that?
you have an approval and no problems, but if they have a problem, even though you gave an EIS, they may have a question on that.
Well, they don't really have jurisdiction. They're allowed to comment, so I wouldn't come back here.
Right. So, right. So just to be clear, Environmental Commission is advisory in nature. With that being said, the board can request a condition that if they, if the Environmental Commission does find something, I guess they would come back and,
Why don't we just say we'll comply, rather than coming back? Why would we come back to the board for a hearing?
I would want the same thing for the fire. We don't have the updated fire.
Have that next too.
Yeah.
right. So,
Well,
how,
it's an
how-
outside
comply.
agency. Fire's an outside
Yeah, so-
agency. They'll have to comply.
So technically what we do is that all right, so we have a list of outside agencies. Pursuant to the municipal land use law, the outside agencies, they can be deemed compliant during resolution compliance. With that being said, they have to comport with the outside agency's recommendations, right? If they don't, then there's typically, a appeal process involved in that. If anything within an outside agency's recommendation changes the site plan, that may trigger an appearance before the board via a waiver or a variance or something of that nature if in the event things are changed in the plan. So if they agree to comply with the Environmental Commission
Findings.
letter, findings, finding of no interest or finding of interest, and they comply with everything in there, then, and there's no triggering mechanism for them to come back. Technically, they would need to come back. If something does get triggered, it doesn't matter if it's fire or traffic or environmental or whatever, then they would have to come back, right? So there has to be some kind of triggering mechanism in which the board obtains jurisdiction again to have another hearing on that. And that typically happens via variance or waiver, where plans are changed during the resolution compliance period and they have to seek board review again. If that makes any sense to the board members.
And you agree with that, Ms.
Yeah,
Jennings?
we will stand on the record that we will comply, and obviously if they come up with some crazy condition, we'll probably come back here and tell you why we don't want to do it.
Fair enough.
All right. Now, we
I do have one more question for
okay.
Mr. I'm sorry.
No problem.
I'm sorry. On page 3 of your report, you have design year 2036, no build, AM and PM peak street hour traffic volumes.
Okay.
What about the build?
The build is the, okay, you're talking about the figures that are in the appendix.
Sorry. I'm actually talking also about the trip generation that you have on page 3. Is that only no build or does that include build?
That's added to the way it works. We developed the no-build traffic volumes, which if you go into the appendix, they're on figure 3. That includes the other 4 projects that I mentioned that are along the South New Prospect Road corridor that we're familiar with. Those 4 specific projects, plus the growth rate. That's how we develop the no-build volumes. And then on figure 5, we surcharge that table, that traffic that's in the table, that's surcharged onto the no-build volumes, and that's what we call build traffic volumes, which are the following figure. So they're surcharged onto the no-build volumes.
Okay, thank you.
I'd like to make a motion to open to the public for cross-examination of this witness and this witness only for this application. Sullivan.
Second, DiMarzo. Aye.
If anyone has any questions for Mr. Ray, please come forward at this time.
Seeing no one come forward, I move to close the public cross-examination of this witness. Sullivan.
Second, DiMarzo.
Yeah, all the experts are done.
How about general questions?
I'd like to make a motion to open for public comment on this application and this application only. Sullivan.
Second, DiMarzo.
All in favor?
Aye.
Aye.
Nope, you got a race. Yeah.
Okay, just a general.
Hang
Oh,
on.
I gotta do it
Yep,
again.
Yep. You swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right. Please state your name and spell your last for the record.
Carlos, M-A-R-T-I-N-S.
All right.
And yeah, I'm here as a resident, although I belong to
Gotcha.
the zoning board. Okay. Just a general comment for your consideration. So a few experts have brought up the fact that this applicant already operates built a school.
Daycare center.
Thank you. Daycare center in Lakewood. Okay. But there's no testimony here saying that it's operating correctly, that there's no issues with the neighbors or anything like that. So when you consider that, what their experience has been, I think you should take into account that there's no testimony given to certify that they're doing it correctly.
But
That's all I want to say.
Just to be fair, every application's got to stand on its own, and it can't take into consideration enforcement perspectives from other townships. So
Right,
just-
right.
yeah.
I just bring it up because the applicant or the experts brought up the experience that this, and they took that into account when they came up to the expert opinions. So I just want to bring that out. That's all.
Thank you.
Thanks.
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right. Please state your name and spell your last for the record.
Deb Jones, Jones. It's really just a general comment.
I think you have to just move over a tad because you're getting feedback from that mic. Or that mic.
All right, I'll step back.
That's great. Thank you.
My general comment is when we were talking about fire safety and evacuating the building, I just wanted to make mention that kind of scares me when we talk about people just grabbing two kids and going. I mean, you can say there's other staff members, but you don't know where a fire's breaking out, who can get to your room, who can't get to your room. They make cribs that are designed for evacuation. They're made out of metal, they're on wheels, and you put multiple kids in them. I just wanted to put that out there for, I guess, the owners, because I don't want to see anyone's baby or a staff member getting hurt during a fire. And if they're required to do fire drills, then they would be using these for fire drills, and it would become second nature to them, and it would just be safe for everyone involved. That's all.
Yep, the state has very, very, very stringent checks, balances, and drills all built into these systems, especially.
I know they do, but they don't always build in the cribs.
I think something like that, I never thought of something like that, but especially that they're down in the basement and they have, if the applicant, they got one room.
I think it was an excellent suggestion, and
In the 30 months, they got one room, they could put,
perhaps
up to
we
12
could
kids,
get
but-
some testimony on that.
two cribs there would cover it.
You swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes.
All right, please state your name and spell your last for the record.
Ephraim Perlstein, Perlstein.
All right, your address?
802 Morris Avenue, Lakewood, New Jersey.
Are you,
I'm the applicant.
He's the applicant.
Correct. Yeah.
okay, do you want to,
And would you like to answer?
Yeah, I just have one comment to make. In our daycare that we operate, which I am an owner-operator, not an investor, so I'm actually on the floor. Firstly, we have fire drills monthly. With the login sheet, we have to log in, my staff need to do that. With the times, we make sure it's kept to the state minimum of under 3 minutes per evacuation. Secondly, the state requires to have the 2 ramps on the side as evacuation at grade level, and they consider the ramp grade level. We have evacuation cribs, so no one's taking out 2 kids as they go out. They have evacuation cribs, which are, you can go online, you can see them on Amazon or any school website, Scholastic or anything like that, and they are made and manufactured commercially, specifically for this situation.
and you'll stipulate as to having those cribs?
We will stipulate that we will have those cribs, adequate of cribs per room. When we have inspections, Mrs. Chamble had mentioned many times she seems to have a lot of experience in schooling, and I appreciate that. And you sound very knowledgeable in this area. When they come down to the classrooms, they count to make sure that there's adequate cribs, adequate staff in order to be able to do these evacuations under 3 minutes.
Thank you, we appreciate that.
Thank
And
you.
I hope that answers your question, Ms. Jones. Good, thank you so much. Anyone else like to come forward at this time for comments?
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? I know, you got to do it every
My
time.
best shot.
All right, please state your name and spell your last for the record.
Eric Jones, Jones.
Same address.
Oh, 722 High School. When I look at this plan, the only thing that concerns me is where the dumpster is. The corner of that lot jets into that person's property. I don't know if you looked at the outside, people. But that dumpster is right next to somebody's swimming pool. Now, let's say it doesn't get picked up. We're talking dirty diapers, food, all that kind of stuff. And you guys were talking about eliminating perhaps some parking spots. I know a lot of times you don't like to put a dumpster by the street, but I think the better place to put the dumpster would be by
On the left?
By the exit on the bottom.
Oh, I don't think we can put it by the exit on the bottom because that would be on the front of the property and we don't do that. However, how about
But I just
putting in
you know,
parking spaces where the dumpster is now and moving it over to the left?
it's still the way that the corner of that property jets, you have to look at it on a map. I don't know if you guys can blow that up or anything, Anthony. I don't know if you can back that up at all.
Can we go to the aerial? I think there's an aerial of this
It's
property.
just the weird shape of that property where it jets into the corner of somebody else. Their yard actually goes around the point. You know what I'm saying? It's like, and then their swimming pool's like right there next to the dumpster.
The swimming pool is right next to the section that is not,
Now, not that house. The other house has a swimming pool
Yeah.
right there, right next to the thing, right next to it.
you're looking to the right.
Not the blue, not that pool. There's another pool there that you really can't see. It's right on the property line almost.
That would be what, over 30 feet from the property line is this location?
Well, you know, dumpsters. and
Plus,
stuff, you know.
how about screening,
Yeah,
maybe?
there's a 25-foot buffer all around the perimeter. Plus, the dumpster itself is probably 35, 40 feet away from the property line.
And then how about putting maybe additional fence or planting
There's
to
plantings all around the dumpster as well.
tall?
And I don't
Yeah, they're
know-
tall. We have,
Okay.
I don't know why you would want to have your dumpster next to your play area either. That just,
Well, I think it's a matter of the truck coming in and backing up.
I'm saying the play area, the children's play
Yes.
area is like there and there's the dumpster.
It's also an enclosure, correct?
Doesn't seem.
correct, it's enclosed.
Okay, it is enclosed.
I don't know, that's the only things that I was thinking about.
Of course, these are
I'm
not-
just surprised there's no neighbors. If this application get a notification?
Yeah, of course.
Of course.
100%, yes.
100%.
Has this been carried and nobody else was re-notified?
No?
I'm just surprised nobody's here. I wouldn't want this in my backyard, honestly. But anyways, and I'm assuming by the
Re-notice.
size, of this, it's gonna be another clear-cut operation? Where they're knocking
Oh,
down
but
every-
I believe that there
knocking down
was
every
testimony, from the forester. There's quite a
Well, the forest will be a lot of
extensive
trees
letter.
once, but things change on site.
There'll be a lot of trees
I've
planted.
seen it. What's that?
They'll be planting a lot of trees for buffer?
I don't know, it just doesn't seem like there's much property left to have a buffer. You know, because what's between the parking lot
They had a colored rendering of it.
and the property line?
Anthony, can you bring up
25 feet?
Can you bring up the,
Color
Colored
rendering.
site rendering, the landscaped exhibit.
There's a landscape exhibit.
I know, just around this town, it's just like everybody talks about character.
It's colored.
And we're just totally losing the character when we're clear cutting everything.
I think we're getting away from the general comment nature
Yeah,
of,
I get what you're saying.
Yeah.
but
there it is.
There it is.
It's just some thoughts that you can, I don't know.
Yes. You see the
The landscaping.
landscaping and the planting that's going to take place.
Yeah, but what's that distance? I thought somebody said 25 feet.
40.
40 feet.
From the edge of the parking lot to the property line.
No, from the edge of the parking lot would be about 30 feet.
I think somebody said 25 feet.
The buffer, the double staggered line is 25 feet.
That's what I thought. 25 feet doesn't give you any privacy at all. Zero.
Thank you, Mr. Jones.
Yeah, 25 for the parking, yeah.
Anyone else?
Seeing no one else come forward, I move to close the public cross-examination on this application. Sullivan?
Second, DeMarzo.
All in favor?
Aye.
Ms. Jennings?
Sure, I'll just be brief because I think that we had a very good discussion and a lot of good comments from the board members as well as the board consultants. And I counted over 30 agreed upon conditions for an application that is variance-free and with 3 design waivers that are typically given by this board. So I would respectfully request that the board granted approval this evening, subject
you.
to all the conditions.
if we could just summarize the three the 3 waivers, just for the
Sure,
record.
they're in Mr. Peters' report on page 9, and they are specifically number 5, 6, and 7.
Good to go.
Thank you.
And there are no variances.
No variances.
Mr. Peters, any comments for us, please?
Just a reminder that one of the many conditions that was agreed to is that the building height will comply with the ordinance requirements, and they're not asking for a variance for building height.
Correct.
Mr. Klee?
Just really briefly, there was some discussion about outside agencies and the need to come back or whatever. I'm pretty much the curator, the gatekeeper of, is the outside agency approvals adequate? Are they proper? And I can assure the board that they will be.
And members of the board, any comments before we go to vote?
am concerned about the fact that, we have to put our ordinance that we had in place that had specific conditions aside for state, because the state law governs. But I would suggest to Mr. Bressi, if the town council would take another look at this, and that this is an unusual one, and we approve tonight, that this doesn't necessarily mean that this is going to be what happens in the future if we can get an ordinance that has more design standards to it. Thank you.
And you're absolutely right, Ms. DiMarzo, because each application stands on its own. There's not precedent here.
And to make the point, ultimately, the arbiter of this will be the state because it is a daycare facility, and ultimately, it will have to pass the regulatory requirements of the state.
And no matter what we put in, we put anything in, and the state overrides us. If we fight that, the only people that win are them. So but it's worth looking at.
Right, and just to be clear, so what the board is going to be voting on is, number one, all the conditions that have been posed. Number two, if the board wants to deliberate as to the nature of the waivers, they feel free to do that. As indicated multiple times, a test for a waiver is that it has to be reasonable in nature. It's got to be within the purpose and intent of the ordinance provisions. Literal enforcement of the ordinance provisions is either impractical or will exert undue hardship. So that's the legal standard. If the board wants to deliberate upon that standard in light of these three waivers, but there are no variances in this application, and it is a permitted use. Right. So the three waivers are that of all entrance drives shall extend to a minimum distance of 100 feet from the street right-of-way or parking aisle per 244-197J2. All exit drives shall extend a minimum distance of 60 feet from the street curb or to a parking aisle per 244-197J2, A2C. No parking stalls shall utilize the required entrance and exit drives or major circulation drives as parking aisles, whereas the parking access to the main circulation drive. Those are the three waivers that are in front of the board.
There's actually one more I forgot about. Mr. Halper testified to it. There's no structure shall be permitted within the buffer area, and there's that one small retaining wall that's in
Gotcha.
the
The retaining
buffer area.
wall, right.
Yes.
Mr. Bressi has a question. Yes, that was decided. One space on each side will be removed. That was agreed upon. Was one of the 33 agreed upon.
Correct.
That is it for me.
All right, we'll accept a motion, please.
I'd like to make a motion to approve this application with the stipulations and the design waiver. Sullivan.
We have a motion and a second. Roll call, please.
Mr. Bressi?
Yeah, I'm basing my motion on one, the amount of stipulations and complying with them. No variances. The county improvement on that road is tremendous. And for the owner to come testify of something I learned tonight after many years up here about cribs that could be used for fire evacuation was eye-opening, and it's nice to know about it. And I think with all the stipulations and all the professional testimony from Al's and their professionals, I vote yes.
Mr. Marzo?
Unfortunately, I don't agree with Mr. Ray on this, with the waivers this go-round. I understand that he feels that it's for shopping plazas, but there's going to be a lot of traffic here, and so I'm denying a no based upon the waivers. I'm not going to grant any. Thank you.
Mr. Parks?
I vote yes, mostly for the reasons that have been previously stated.
Mr. Rogers?
I'm conflicted on this application, recognizing the applicant's right to develop his property, and the township and community's right.
Mr. Sullivan?
I'm going to vote yes because of the stipulations that they agreed to, because of the fact that they're willing to work with the arborist to make sure that there is proper plantings that will make this project more tolerable for its neighbors. Given the fact that they've been willing to work with us on this, I vote yes.
And Dr. Campbell?
There are no variances, and we've had a great deal of agreement on a number of issues, very sensitive issues, and I vote yes.
Thank you so much. Have a good night.
Congratulations. Have a good night. We'll accept a motion to adjourn.
I'd like to make a motion to adjourn this meeting. Sullivan?
Second, DeMarzo?
All in favor?
Aye.
Aye.
Thank you, ladies and gentlemen, for your time.